they concede that judicial oversight is within the powers of this court as regards the impeachment proceedings. They then muddle up their submission somewhat at paragraph 107 by stating that impeachment is a purely political process rather than a judicial one. At paragraph 107, they seek to limit the purview of this court's mandate by stating that the court review of the decisions or the process does not include interrogating substantive merits of the impeachment charges. They, however, concede at paragraph 109 that this court has jurisdiction and power to examine whether the constitutional and statutory procedure for the impeachment was followed lawfully. That's paragraph 109. They concede as well at paragraph 109 that this court can examine the question as to whether the petitioner's rights were violated. I believe they are citing a decision of the Court of Appeal in making that concession. They then repeat at the same paragraph that the court cannot reevaluate or substitute or interrogate the substantive merits of Parliament's decision. And I'll be demonstrating to this honorable court why that is not the correct position. Having conceded that public participation is necessary, as they have at paragraph 95, they then seek to somehow circumscribe their concession at paragraphs 292 and 294 by saying that Senate did not require to conduct public participation. It's the boldest statement negating public participation I have ever had by a state organ. At paragraph 183, they make the point that fairness is required as a part of the process and that it requires careful consideration. And as regards what my learned senior counsel, Mr. Paul Mwite, alluded to here earlier this morning regarding the events of the night when the IBC was consulted leading to the nomination of the current deputy president, they make the point at paragraph 380 that the National Assembly was not conducting a normal vetting process. It was a vote. In fact, they make the point that it was an election. Those are the words they use. And this is now to be found in the submissions of the first and eighth respondent at paragraph 68 to paragraph 70, that the president, in consulting IBC on that night, was not doing so as a matter of constitutional requirement, but was doing so as a matter of abundant caution. He was being careful. He didn't require to do so. Those are the points they make. Now, this court is imbued and clothed with authority, first and foremost under Article 22 of the Constitution of Kenya, and I don't need to read all the remedies that are set out therein. But among those that are set out there and relevant to our client's case, one is compensation, E, and F, an order for judicial review. And then at Article 165, Subarticle 6, the High Court has supervisory jurisdiction where it is examining a decision arising from a quasi-judicial proceeding. And this is important for reasons that I will make known shortly. Now, I call this court's attention to Section 11 of the Fair Administrative Action Act, and it's an important act for many reasons, because whereas Parliament has made very lengthy submissions on many things, Parliament constitutionally talks through the laws it passes. This is a law Parliament passes directing what is to be fair in a proceeding such as this. And I begin first by making the point, and the respondents agree with me on this, and I'll be demonstrating where the submissions. They say that the Senate proceedings were quasi-judicial. That is the word they use themselves. And perhaps I think I should actually identify the exact paragraph where they say, I believe this is paragraph 292 of the submissions, where they say that the Senate was exercising a quasi-judicial authority. Yes, indeed, at paragraph 292 of the submissions by the National Assembly itself. And this is what they say. We submit that the Senate's function under Article 145 is not a legislative function, but a quasi-judicial and adjudicative role. The words quasi-judicial are the same words appearing, as I've stated, at Article 165, sub-article 6, but perhaps more importantly, under Section 2 of the Fair Administrative Action Act, and the Act begins by stating, this is the rationale for the statute by Parliament itself, this is an act of Parliament to give effect to Article 47 of the Constitution of Kenya. And this is what they say. Administrative action is defined as the powers, functions, and duties exercised by authorities or quasi-judicial tribunals. And so, by concession, by admission of the Senate, the decision, the process they undertook was quasi-judicial and therefore amenable to the Fair Administrative Action Act. And this is important because at Section 5, the statute says that in any case where the proposed administrative action is likely to materially and adversely affect the legal rights or interests of a group of persons or the general public, it then says what must be done. Amongst the first things that must be done is that there must be the issue of a public notice of the proposed administrative action inviting public views in that regard, public participation. Senate was required by the statute, by Section 5, to conduct public participation. They have admitted they did not do so. Number two, they are to consider all views submitted in relation to the matter before taking the administrative action. They were to consider everything said to them during public participation. They elected not to do so. They are to consider all the relevant and material facts. And D, where they proceed to take the action, they are to give reasons for the decision of the administrative action as taken. Again, they did not do that. That was not done. Now, and my good and learned senior here, Mr. Swanya, will be coming to give a few more details on the question of public participation, and I'll touch on a few others. But then, at section, I believe, section 7, subsection 2, this court is provided with a marking scheme. It is to apply when considering whether administrative action such as this met the test of the Constitution and of the law. I have been shocked in my own examination of the question to find that the National Assembly and Senate reached a mark. The examination mark was equivalent to my Form 2 physics examination, 0 out of 100. That is the figure they found. A self-supporting 0, and I'll proceed to demonstrate the points. Section 11, Section 7, subsection 2, I've read out to the court, states that the person who made the decision, and this is one of the criteria that the court is to look at, whether that person was not authorized to do so by the empowering provision. Now, you've been told, and as I've pointed out here, the respondents make the point that the president was only acting as a matter of abundant caution. Now, it is not in dispute, I think it is common ground between us, that the IEBC did not have commissioners or a chairperson. In 2025, the Supreme Court of Kenya handed down a decision. It is part of our list of authorities. It's called IEBC versus the Attorney General 2025. At paragraph 62, this is what they say. It is uncontested and indeed a matter of public record that at the time of filing of the present reference, IEBC was not fully constituted following the exit of its previous commissioners. There was at the time no indication as to when new commissioners would be appointed. As such, the commission remained for all practical and constitutional purposes incapable of discharging functions that by law require the participation, deliberation, or approval of a properly constituted commission in accordance with Article 251 and 252 of the Constitution. That is a binding decision on this court, and if there were any doubt as to whether the president was actually required by law to do this, or whether he was actually acting as a matter of abundant caution, as it states, I call the court's attention to Article 88 of the Constitution of Kenya, the provisions of the IEBC, the Elections Act, as regards what a nomination is, and with particular attention to the definition of the word nomination. Amongst the other things, the Speaker of the National Assembly had no authority to approve a motion that was based on a law that was declared unconstitutional, because it cannot be a high offense. It cannot be a violation of anything. You cannot violate that which does not exist. That is amenable to review by this court. One of the other tests is whether the decision was made in excess of jurisdiction or power conferred under any written law. Now, the Senate, as senior counsel here said, worked with ungodly speed in impeaching the first petitioner before you here this afternoon. But apart from that, as regards the appointment of a replacement candidate, the Constitution has 74 days within which this decision could be made. 74. It was made at night, within less than 24 hours. So this kind of, there was no power to act with such ungodly haste when you are allowed 74 days to take your decision. Now, the speakers of both the National Assembly and the Senate, as my good friend Elisha Ongoya said here earlier, were beneficiaries and signatories of shareholder agreements which have been placed before you, which formed the basis of grounds 1, 5, and 6 of the impeachment motion. One of the fundamental rules of natural justice is that you cannot sit in judgment of your own cause. They were sitting in judgment of a cause in which they were not only beneficiaries. In the case of the National Assembly Speaker, who I have tremendous regard for, he was a signatory. As senior counsel here said this morning, the replacement, Honorable Kithure Kindiki, Professor, a man I have a lot of regard for as well, was the witness of those agreements. The President of the Republic of Kenya signed and bound himself to those documents. And it's important to understand that these documents were not being done as a matter of abundant caution or as a matter of political games. The Political Parties Act requires a coalition agreement to be the foundational document for a coalition. So the Kenya Kwanza government is founded on the basis of these shareholder agreements. And when the deputy president, elected on the basis of those shareholder agreements, insists that those agreements must be complied with, he's called a tribalist and he's impeached. As Jesus would say, first take the log from your own eye. Impeach yourself as the government first for basing your government on a tribal agreement. Then get rid of your deputy president. Now, the National Assembly was scheduled to vote for the nominee to replace the petitioner before the Senate had voted. Again, senior counsel spoke to that, and I won't say much more. But what I will say is that last year, the High Court handed a decision, and I believe this was a 3 or 4 or 5 bench decision, and it's part of our list of authorities, in a case called Njiro and 11 others versus Kenya Kwanza Coalition and 18 others. It's part of our bundle of authorities. And this is what they said at paragraph 489 of their decision. We hold and find that the simultaneous holding of the position of Speaker with that of the leader of a political party and the leadership positions in the ruling political coalition, as is the case with the current National Assembly Speaker, Honorable Moses Wetangula, who is the leader of Ford Kenya and a holder of key position in Kenya Kwanza Coalition, reasonably evokes appearance of bias. And I say this because bias is one of the tests Section 7 of the Fair Administrative Action requires you to look at. And I continue. And undermines his neutrality role as the Speaker of the National Assembly and the independence of Parliament as the symbol of democracy, negatively impacting on our democratic standards as envisaged by the rule of law, principle, and Article 10(2)(a) of the Constitution. And this is what they say. This dual role is unlawful and unconstitutional. I am aware that the National Assembly sought to stay that decision, and that attempt to stay was rejected by the Court of Appeal. There's a decision available on the Kenya Law website. And so, where you have a court decision stating that the referee, the man conducting this impeachment, the man issuing the decision, the man reviewing the motion is biased, is a violation of the rules of natural justice. One of the decisions we have submitted before you, and my good friend Mr. Dudley is a bit more eloquent on pulling them out of his head quickly. The court has said that any decision emanating from a decision maker in violation of the rules of natural justice is not a decision. Now, when you look at, Articles 95 and 96 of the Constitution, the process of impeachment begins or is initiated in the National Assembly. Article 96 then uses some very interesting words and states that the role of the Senate is to consider and deliberate, not on the motion, on the resolution. Those are the exact words of Article 96. And so a resolution emanating from a process shepherded, led by an individual who has been found to be biased is no decision at all. Now, the person who, this is one of the other criteria that the court is to look at, whether the person who made the decision denied the person to whom the administrative action or decision relates a reasonable opportunity to state the person's case. It is important, while looking at this particular question, to examine, according to the first petitioner, where his problems began. I call the court's attention to paragraph 65 of his further amended petition, in which he states that his problems emanated from exercise of his freedom of expression, Article 33, following demonstrations that led to the unprecedented in Kenya's history occupation of parliament by the citizens of Kenya. That is paragraph 65 of his petition. And the reason citizens of Kenya, who called themselves Gen Z, occupied parliament was that they said they were not being heard. Their participation was not meaningful, and the only solution they could find was to occupy the August House. That is the beginning of this problem. And so when parliament embarks on a public participation process, it is incumbent on it to first advise itself of this history, that this man has been impeached because he made a statement in support of people who occupied parliament. And so what do? And they concede public participation is necessary. My good friend Mr. Swanya will come and address us a bit more on this. But they give Kenyans 2 days to give public participation. When this court retires to look at the report, because what they did, they then collated, they issued forms. These forms had no serial number. These forms had no way of being verified whether these are Kenyans filling them or not. These were just forms that were distributed all over the place. But they then form a report. And when you look at the executive summary of this report, they say that they received 200,000 responses from the whole country. I did a bit of mathematics. 200,000 people as a function of the 14 million people who voted for the first petitioner and his president comes to 0.014 of the voters. Those are the people who participated. Now, I did a bit of maths in A-level. When you round off 4, it becomes 0. When you round off 1, it becomes 0. So there was 0 public participation, mathematically. It's that simple. 200,000 people out of 14 million is 0. A bit like the result I'm about to give you here on account of their compliance with the law. So you have 0%, and these are figures they themselves have given. In the executive summary, they list 10 problems they had with this public participation. They say there was very poor turnout. In one case, I think it was somewhere in KU, 168% people turned out to give their opinion. 68% spirits showed up to give their views in one particular case. And an order was actually issued against this process on that account. They then, in this form, list the allegations against the Deputy President. This is the National Assembly. But then don't give the people what the Deputy President's responses are. And this is not an idle issue I'm raising here, because, as I stated, and under the Fair Administrative Action Act, Section 5, they must give the public the opportunity to consider all relevant material. All relevant material cannot include the plaint, but not the defense. That was a fundamental dereliction under Article 50 and under the Fair Administrative Action Act. They then say, based on these forms of theirs, that from the entire country, all 50 million of us, they received 8 written memorandum. 8. There are 41 petitioners before you this morning. There are more petitioners here than the number of memorandum they received. 8 of them. 1 per province. Kenya used to have 8 provinces. So again, on average, we got 1 memorandum per province of Kenya. That is what we call insufficient, inadequate, unreasonable, unlawful, unconstitutional. One of the other criteria the court is to look into is, and I think I should point out at this point here again, reasonable opportunity of being heard, which we'll find is one of the criteria. I won't say much about it. Senior counsel has dwelt at length about it. The Senate is informed that the Deputy President is unwell. They even ask senior counsel, it's part of the Hansard, to convey quick recovery to him. It's actually there. They tell him, go tell him to recover quickly. Pray for him. They then say, but while you are praying for him, we will proceed here to hang him as you are praying for him. This is what they did. Now, how are we ever going to face Kenyans? By telling them this is what a fair hearing in Kenya looks like. As we are praying for you, we are slaughtering you here. We are praying for you with one hand, slaughtering you with the left. How are we ever going to face Kenyans and tell them that is the kind of justice we practice in this country? How are we ever going to tell them that is what Article 50 as regards a fair hearing means? One of the other criteria is that did the decision maker omit or fail to take into account a critical issue, or did they omit a condition prescribing the power they are to follow? My good friend Mr. Dudley here again has talked about the Senate proceeding to vote without appointing a special committee. The court has enough material on that. But the courts, and I say so with tremendous respect, will also have time to look at what the Supreme Court said as regards this committee. It said, we recommend the committee route as opposed to this lynching. The words lynching came from them there. Mob justice, goon justice. They said, do a committee. You'll have time to look at that. I've said they did not conduct a constitutionally compliant public participation exercise. And as I said, it's required not only by the law, Articles 10, Article 118, Section 5 of the Fair Administrative Action Act. But again, my lords and your ladyship will have time to look at the BAT case, again the Supreme Court case, that gave the 8 or 10 criteria that are to be looked into in examining whether public participation was properly carried out or not. Among the other criteria that the court is to look into, again from the same Section 7, is whether the administrator failed to take into account relevant considerations and took its action or made the decision in bad faith. Did they consider everything they ought to have? I have a long list of things here, and I won't spend any narration on them. One, they did not take into account the Wambora Court of Appeal principles on the threshold test for impeachment. That is where the threshold test was made. They did not take into account the Sonko Supreme Court case principles on the need for a special committee. They did not take into account the BAT Supreme Court case principles on public participation. They did not take into account the Onyango Olo Court of Appeal case principles on fair hearing, and in particular, what is adequate time given the circumstances. At this point, I should point out, when the Supreme Court is determining whether to annul or uphold the president's election, it normally has 14 days. It normally gives a summary judgment and then reserves reasons for many months later, again because there just isn't sufficient time. And so, why the National Assembly and the Supreme Court in 2022 in its judgment actually said we ought to amend the Constitution to provide for more time, you know? Now, why the National Assembly, which has been asked this, and in fact, in 2022, the Supreme Court said this judgment should be served on the National Assembly for them to remedy this question. Both the National Assembly and Senate did not take into account Article 50 on the fair hearing requirements. They did not take into account Article 94(4) of the Constitution, which requires them to protect the Constitution and promote the democratic governance of the Republic. I've already cited Section 5 of the Fair Administrative Action Act and other provisions of that act. The resolution by the National Assembly adopting these allegations, which concerned spurious, frivolous, vexatious matters about the first petitioner's family matters, which had been dealt with by a succession court, which was the subject of rulings by the family division, were thrown in just for the heck of it to harass the man, and were designed to violate his rights under Article 31C, which protects every citizen from having information relating to their family or private affairs unnecessarily required or revealed. And in the fullness of time, you will find the Senate actually refused to uphold this ground. The ground had been put there purely to embarrass him, to embarrass his family, to embarrass his supporters, to harass the man. That cannot be a proper motive. That is an improper motive by this party. They failed to consider that the DP, and again, this is the Alai case. My good friend, Mr. Dudley, referred it to the Alai case. In the Alai case, the court said, and there'll be another case I'll be reading out here for you shortly, called Ferdinand Waitito, that you are free to express your opinion. And so, as I said, the first petitioner begins at paragraph 65 by saying all his problems are because he spoke about the manner in which his government had mismanaged the demonstrations by these young people called the Gen Z. Now, we are about to compensate them for shooting and killing them. Now, this will be the first judicial decision that will provide guidance on the interplay. This is an important one because it keeps being repeated, and my learned friends here have paragraphs upon it in their submissions. the interplay between hate speech and incitement, which are stated to be offenses under sections 13 and 62 of the National Cohesion Act, vis-a-vis the freedom of expression under Article 33, the political rights at Article 38(3)(c), and the rights of all citizens, including political leaders, to advocate for and protect, express ethnic rights identified in the Constitution. I say ethnic rights with that reason. The first petitioner is accused of stirring hatred, potentially inciting people, because he used the word Mount Kenya. The little geography I learned, Mount Kenya is a rock in the middle of Kenya. It is not a tribe. It's a stone in the middle of Kenya from which we got our name as a republic. Even if you are to count the counties that surround it, they constitute people from every corner of Kenya. They don't have one tribe. He didn't use a tribe. He said Mount Kenya. Mount Kenya is a rock. He can talk about a rock. Number two, even if he was talking about ethnicity, Articles 21, 27, 63, 90, 91, 100, 130, 232, 241, 246, 250, and a myriad of statutory provisions that I could bring here, all talk about ethnicity as a constitutional principle worth defending, worth being held to account for, worth advocating. All of those mention the word. In fact, I found that the word ethnicity appears more times than the word economy. Economy appears twice. Ethnicity 11 times. So, how can you be accused of speaking of an issue the Constitution spent 11 articles talking about? But even more important, in 2016, the late Justice Louis Onguto had occasion to consider a case I have circulated to my colleagues this morning after I got their submissions, and I think I have given the court, my good friend Mr. Njomo, the court's copies. But this is the case of Ferdinand Dongo Waitito, also known as Babayao, and 4 others, versus the Attorney General. It's reported. This is what Judge... such as those about to be made by the respondents. And this is what it says. The Constitution allows every person to picket, demonstrate, assemble, and present petitions. Picketing and demonstrations themselves invite the right to express opinion. The opinions may be controversial. The opinions may appear contrary to the law. Appear contrary to the law. This is just Jayongo saying this. The opinions may not find favor with others. Yet, the Constitution anticipates and expects that such unpopular opinions, howsoever expressed, be respected. Now, not all of us can speak as good English as my good friend Dudley or my good friend Professor Ojiambo here. But you're free to express yourself as you will. If you read a document that talked about shareholders, that is what you say when you go to the public. Why would you be vilified and impeached from ever holding public office for reading a document that founded a government? On what basis? He then says, even if they invite disagreements and counter demonstrations, this is the first time, I think it's good, Kenyans would know, counter demonstrations are allowed. Not just demonstrations, even counter. The Constitution thus far declines to stifle even the most unpopular view unless it is intended to incite persons to violence, propagate hate speech, is propaganda for or advocates hatred through ethnic incitement. When you retire to look at the provisions of the National Cohesion Act, sections 13 and 62, that are the basis of these frivolous grounds, they say the critical function is what my professor, Gideon Muigai of criminal law, used to tell us was called the mens rea, the intention. Did you have the intention to cause hatred and incitement? You cannot have had the intention when the document you are reading is the basis for the government that was formed. You cannot incite people with the government. You reward them with a thing nowadays called power and economic empowerment. You do not incite them. You can't cause hatred by talking about a government that was elected by people on the basis of a document. And so the DP's public references as regards these shareholders cannot be tantamount to hate speech. They cannot. This is public speaking, as I've just stated. And I should state here, the case of Ferdinand Ndung'u Waitito and the 4 others, among the 4 others are the current leader of majority in the National Assembly. So he knows this. When they were considering these grounds, he was aware of this decision because he was one of the petitioners. And they were told, no, you can't stop people from talking. Now, but then, they then went to the Supreme Court, the Court of Appeal, sorry. They tried to overturn this decision, and the Court of Appeal rejected that attempt. So this decision, I'm reading Ferdinand Waitito, has been upheld as well by the Court of Appeal. There are many instances where one would be said to have caused the hate speech or incited people or have said things that weren't popular. The first petitioner is accused of having spoken against the National Intelligence Service. When you retire to review the material before you, this is the Senate Hansard, and this is ground number 9, which we'll find at page 64. There is an interesting exchange where my good friend Ekomas Mutuse is being interviewed, is being cross-examined on the question of the NIS. And he's directed to a case where the current president, who, while deputy president, also very harshly criticized the NIS. So criticizing the NIS has not started now. In fact, the current first petitioner, who was the deputy president, should be accused of being a good student of his boss, the former deputy president, who's currently the president, because he too also criticized the NIS. So, and the NIS, as with any other state organ, can and should be criticized. No one is beyond criticism so long as it is well-founded, as turned out in this case. It is made politely. It is stated in good English, relatively good English. Our client spoke some fairly good English. He's a literature graduate. He said nice things. He said them nicely. Now they offended the heart, but you know, no one is beyond criticism. One of the other things, I think, and we've stated this in our petition in submission, again on the question of bias, the National Assembly Deputy Speaker, the 8th respondent, is on record as saying her instructions to execute the impeachment came from a building in Milimani called State House. And one of the things the court is invited to look at is whether the person exercising this decision acted on the direction of a person or a body not authorized or empowered to give such directions. Now, one of the other issues that this court is asked to look into is whether the administrative action is rationally connected to the information before the administration. Again, as I have said, it cannot have been rationally connected to this decision when among the grounds was a law that did not exist, was issues pending before the succession court, was the exercise of freedom of expression under Article 33. I will not repeat the question about the issue, but it's one of the other issues, again, you'll be able to look at. The question of these shareholder agreements, I need not say any more about that. But is the decision unreasonable? The ungodly rush to execute a premeditated decision is unreasonable. A one-day notice to the public to conduct public participation regarding a matter that even this court has said is of great public importance is unreasonable. Conducting public participation in which the public only has access to the impeachment motion, a summary of it, by the way. The evidence was not given to the public. They were just told he has violated Article this, Section this, and Section that. Most lawyers could not tell you, with the most, leave alone the public, other than my good friend Mr. Umtata. No public member can read these sections out of their head. And yet this is what they were given on this document and told, should we impeach this man or not? Passing a resolution based on public participation, as I said, that had 0% of voters who cast the votes in 2022 is unreasonable. One of the other criteria is whether the administrative action or decision is not proportionate to the interests or rights affected, and whether the impugned action or decision violated the legitimate expectations of not only the deputy president, but the nation at large. Now, the case I cited earlier, which is the 2025 IEBC versus AG case, uses the following, states the following words. Kenya's history is one of executive overreach and institutional compromise. This is what the Supreme Court said last year. And for the avoidance of doubt, Section 12 of the Fair Administrative Action Act states that the Act is in addition to and not in derogation of the general principles of common law and of natural justice. Now, as I said, the National Assembly and the Senate violated all known canons of fair hearing and constitutional procedure. Amongst the most harmful things they did was to destroy almost the principle known as the principle of legitimacy. The principle of legitimacy has 3 pillars. Pillar number 1, people must have voices and their voices must count. That's the first pillar of the principle of legitimacy. The second one is that public affairs and the law must be conducted with fairness and justice. That too was violated. And thirdly, that laws and rules must be consistent and applied evenly and predictably. I repeat, the current Deputy President is the witness of these shareholder agreements that led to the impeachment of the Deputy President seated here. The President, the Speaker of the National Assembly, the Speaker of the Senate, all are members of parties that signed and are beneficiaries of this agreement. How can we say the law is being applied equally, fairly, and evenly, even in the limited space of the political players, when one group is treated one way and one individual is treated another way? I want to rest this area of my submissions, and perhaps maybe you should allow me to just read for you, as I found my notes on the provisions of the Elections Act and the IBC Act that deal with the question of nominating a deputy president. These are articles 82(1)(b), article 88(4), the definition of the word nomination at section 2 of the Elections Act, section 22 of the Elections Act, and section 4D of the IEBC Act. I want to close with the following paragraph taken from the decision of the IEBC versus Attorney General 2025 case. This was a case concerning the delimitation of boundaries, and the Supreme Court of Kenya said as follows. And this is the penultimate paragraph of their judgment. However, before we conclude, we must address a matter that has troubled us. And it is my very, very tremendously humble and respectful request to this court to also be equally troubled by the things that the National Assembly and the Senate did in this matter. The history of Kenya's electoral process, from the findings of the Kriegler Commission after the 2007-2008 post-election crisis, to the litigation around elections culminating in the 2022 presidential election, reveals a consistent theme, one of a deep-seated trust deficit. I beseech this court, do not countenance any further trust deficit based on the things the National Assembly and the Senate did. Trust deficit between Kenyans, the IEBC, and the electoral process. This deficit did not occur by accident. It occurred because of actions like the ones by the National Assembly and the Senate. Rather, it is the product of decades of politicization of the electoral process, relentless attacks on the Commission's independence, and a failure to implement electoral reforms in a good time and in good faith. Leaders exercising delegated authority, such as the National Assembly and the Senate, on behalf of the people under the Constitution, rather than fueling this mistrust for short-term political gain. It appeared last year, 2024, when the impeachment was going on. it seemed that there was a deadline by 20th October. And when I slept, I woke up with a eureka moment. The idea was to have a new deputy president at the holiday. You know, it gripped me. I hadn't seen it before, you know. And so undermining the very institutions they are duty-bound to protect should channel their power and influence toward addressing structural weaknesses, enhancing accountability, and reinforcing public confidence in the impartiality and competence of the IEBC. In this case, I say of decisions by the two bodies before you. Ultimately, the legitimacy, which is why I spent some time talking about the doctrine of legitimacy, and this is what they say. Ultimately, the legitimacy of Kenya's democratic order depends not only on credible institutions, but equally on the fidelity of political actors to the spirit of the Constitution and the sovereignty of the people, which was in question during this impeachment. Unless your ladyship and my lords have any questions for me, I want to thank you for the privilege of your time and attention. I'll rest at that point. I hand over to my senior, Mr. Swanya.
Thank you. I would like to make this comment that repeated issues are coming up in your submissions, and I want us to believe that we have heard most of those issues. If you find that you are bound to repeat what has been said, we want to assure you that it is not necessary.
Thank you. My name is Swanya. I'll address the court on notices. But before I do so, let me cite the Supreme Court, a case on PAT, which says public participation is a constitutional requirement under Article 10 and 118 of the 2010 Constitution. The Supreme Court in a PAT case held that public participation and consultation is a living principle that went into the constitutional tenet of the sovereign of the people. Under Article 10, Sub-Article 1 and 2, as a constitutional principle, public participation binds and it is applied to all aspects of governance. Your Honors, and Lady, I want just to get down to some specifics on public participation. It is designed to ensure accountability, requiring public engagement, rather than just parliamentary approval. In the context of impeachment, it is a remedy of the last resort. This, I think, was mentioned by Senior Counsel Paul Mwite. Therefore, the public participation exercise must meet the following standards, and this is what I wanted to get down to the specifics. One, must be purposeful and meaningful. Must be real and not illusory formality. It is not cosmetically done for Public Relations Act. Should not be undertaken as a matter of just to fulfill a constitutional requirement. The public participation exercise outcome must have quantitative and qualitative components. It is accompanied by reasonable notices and reasonable opportunity. Further, Your Honor, the court tried to highlight what is the components of meaningful and purposeful public participation. It must have clarity of the subject matter of the public, for the public to understand. The structure and process, that's the media of communication, of the participation, participation that are clear and simple to understand and follow. This particularly is the instruments that are used to collect data ought to be given to the participants on public participation, they got to be simple, clear, and easy to follow. There must be opportunity of balanced influences from the public in general and commitment to the process. It must be inclusive of effective representation, integrity and transparency of the process, and capacity to engage on the public, including that the public had to be first be sensitized on the subject matter. These are the details that our guidelines the Supreme Court gave on the PAT case. So now let me just get straight to the notices. Before I get to the details of it, let me define what a notice is and a reasonable notice. A notice is a formal information to parties attached or necessary to a judicial process, informing them about the issues they need to know and given an opportunity to respond to them. The courts always will rely on the parties to properly serve notices to the affected parties. A proper notice is regarded to be proper and adequate when it has the following elements. Number one, it must be in writing and indicate the date issued. It must be clear and precise, or state the clear, precise object of the notice. Provide specific venue and duration if necessary. Provide adequate timelines and periods as may be stated in a statute or an agreement. It must refer to a statutory or an agreement or resolutions, and of course must be served. In the case of Battle versus Globe and Mails Limited, 1960, this a Canadian case, the Supreme Court, Ontario, clarified what is agreed, clarified on the reasonable notice, that where there is no agreed timeline in a notice, a reasonable notice kicks in. It is a common law concept that refers to fair amount of time that must be provided for the parties to respond to a matter that concerns them before a decision is arrived. The Lord, I brought this up because we do not have a codified law that guides the impeachment process, which has guidelines on the notices and durations, all steps to be taken for an impeachment. And what we have only is what the Supreme Court, in the case of PAT, has given as guidelines. And so one of it is reasonable notice is necessary. And that's why I've referred this case where there's no notice, then automatically a reasonable notice kicks in, and it talks about the timelines. Now let me state also in the case of Robert and Gachagua versus Governor Kiambu County, the court has been clear that arid or poorly publicized processes amount to illusory participation, being a formality incapable of influencing the decision. Therefore, reasonable notice to the 290 constituencies must be understood as notice that is sufficiently served early, widely disseminated, and accompanied by accessible information for realistically enable the citizens to engage. Anything less, particularly involving inordinately compressed timeline undermines the constitution standard by denying the public a genuine opportunity to study the issues and be able to formulate a position and present meaningful representation capable of shaping the final decision as in the present case. Your Honors, I now submit on the National Assembly's failure to meet the standard of reasonableness and meaningful engagement. The National Assembly, in their own report, reveals a process that prioritized speed over substance, failing the reasonableness test as follows. The notice ran for only 2 days. That is on 2nd and 3rd October 2024 for the public participation exercise, which was to be held on 4th of October 2024 at a purported initially a designated single venue at the county level. Additionally, the National Assembly report on 3rd and 4th October 2024 stated they had 40,000 copies of the notice of the special motion were circulated as newspaper pullouts. This begs the question whether the 40,000 copies were adequate for meaningful national public participation and whether the 2 days were adequate for circulation of the same nationwide. My Lords, we submit that the timeline were fatal to the meaningful engagement because the entire national exercise was condensed into a 4-day window inclusive of the 2 days notice advertisements. This time frame is grossly insufficient for the public to digest a 100-page motion containing 11 complex grounds, legal grounds, including allegations of corruption and gross economic crimes. Your Honor, it's important to note that the first notice had a single venue per county. Your Honor, you can imagine an headquarter of a county, assuming that's where the exercise was taking place. The people who are at the ends of the county, how would they access to reach the venue and participate in the public participation exercise? This is contrary to actually what the Court of Appeal, the Supreme Court rather, guidelines had provided for. The other point, Your Honor, according to the report, the nationwide public participation exercise at the constituency level gave 1 day notice on 4th of October 2024, the same date as the court ruling. Let me clarify here that the participation exercise was supposed to be on 4th of October 2024 for 1 day. But the ruling of Justice Moho, your brother, extended the participation for another 1 more day. Now that advertisement or publication also came in the same day when these exercises were supposed to finish. Now, what would happen that to the common mwananchi? Of course, confusion. Similarly, the orders which were given said that now the exercise should move from the county to the constituencies. Your Honor, what we noticed here is that in the constituencies, just talked about constituencies, never gave a specific place address where this exercise is supposed to take place. It's our submission that such an important exercise to remove the deputy president from office who was elected by the majority of Kenyan in each gazetted polling station in the country required a similar methodology and participation to remove him from office. And certainly, the purported NGCDF officers advertised without prescribed venue address did not meet Justice Mwongo's court order to provide venues close to the people. In any case, the only venue close to the people is polling stations. The honor here, as I said earlier, even with the orders leading to have the exercise done at the constituency level. And the assumption here is that each constituency has these officers. But then what's the distance between where those officers are, the one who's prescribed, for somebody who's at the end of the corner of that constituency? By using highly legalistic language in the notices of public participation and in the circulated public view template, the assembly created a barrier to entry for the average mwananchi, reducing a constitutional right to a binary of support or oppose vote. The report indicates that primary information was posted on the national television broadcast KBC, print media, the parliamentary website, and social media, which was technologically biased and excluded vulnerable groups. In the BPI case, the court stated that relying heavily on technology ignores the reality that only small fraction of Kenyan as reliable internet access, and that technology has not been dispersed equitably to all Kenyans. Similarly, despite the Persons with Disability Act of 2025 requiring free sign language and braille in public forums, the Gachagua impeachment exercise failed to provide even the most basic reasonable accommodation for these 5% of the population with special needs regarding the exercise, which was unconstitutional as per Article 54. The report does not demonstrate that the public was provided with copies of the special motion, including the grounds in English, Kiswahili, prayer, and other communication channels and technology accessible to persons with disability, such as the Kenya Sign Language. In Turkana, as an example, as well as other marginalized regions where the report shows zero response via hand delivery and email, the report does not demonstrate whether it provided any mobile registration units or outreach as required by the PPI case to ensure nomadic communities were also involved. The notice, as I think has been mentioned again, presents a one-sided script. It presents the public with the grounds for impeachment without the first petitioner's response. This was not a search for truth. It was an exercise in prejudice. By suppressing the petitioner's side of the story, the state violated its rights to fair hearing and public's right to make an informed decision under Article 47 and 50 respectively. And this is found in our submissions, page 48 and paragraph 107. One submit that since the reasonableness of the notice is to be determined on case-by-case basis, the adequacy of notice in the present impeachment process can be tested against the scale of electoral mandate it seeks to overturn. This is found also in the submissions, page 47 and paragraph 104. In 2022 Kenyan general election, the presidential mandate was exercised by approximately 14.3 million voters out of about 22.1 million registered voters nationwide, reflecting a wide democratic participation. Out of those who cast valid votes, roughly 7.1 million supported the ticket of William Ruto and Rigathigachagua, thereby conferring upon them the constitutional mandate to govern. This mandate was granted by voters decentralized across the 290 constituencies and dispersed across at least 24 counties in accordance with the constitutional requirements. That is also in our submission, page 4 and paragraph 2. Therefore, by contrast, a constitutionality compliant impeachment process ought to demonstrate that the public participation notices reached a substantial and representative proportion of that electorate. In the present case, the notice issued reached only a negligible fraction of the electorate, attributed to short times, limited publication channels, and accessibility to forums, which processes clearly falls short of the constitutional standards. And of course, my learned friend Tom Macharia has mentioned that this is evidenced by the alleged 200,000 plus viewers in the National Assembly report, which constitutes about 0.14% of the vote that mandated their win. Your Honor, statistically, of course, it sums up to a 0%. If it was a medical test, it will show negative results. There were only 11 memoranda that were presented to Parliament. Your Honor, and again, this I think has been said, I don't repeat it. This begs the question whether the National Assembly is suggesting that the sovereign will of 22.1 million registered voters in the nation is carried in the hands of the 200 plus individuals who allegedly participated in the exercise. Your Honor, as you retire, you will find that the National Assembly's failure to issue reasonable notices contributed to the dismal performances in the public participation exercise, which cannot be taken to proportionately hold the views of the majority who voted the president and deputy president into office. I also dare to say that the mode of the instruments that were used to collect information, the template instruments used in the public participation exercise lacked clarity, thus ambiguous, contrary to the Supreme Court guidelines. The viewers template instruments to collect data from the public participation exercise failed verification and identifiability test. And of course, we have mentioned that initially, which I think is a point note, they were the first templates that did not have provision for identification. Then later, they were replaced. But we don't know the the forms that were already in the public, what happened with them? Did they collect data? Is that data part of what was collected and reviewed? That information we don't know. Parliament equally did not state clearly how they were verifying the information they got from the public. Finally, let me just finish now. I wish, just to draw to your attention, this was your ruling here in this court, in the same case of Gachagua. Gachagua and 40 others, versus the Speaker of the National Assembly, and 15 others. 224 KEH 13473. This is what you stated. The impeachment case exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue, one that has significant implication for the doctrine of separation of power. Your Honors, the eyes of the nation are indeed upon this court. We echo your sentiments in paragraph 101, which reminds us that the people of Kenya fought for a transition away from marginalized judiciary. They envisioned a new order where government excesses are checked and where no harm of government operated beyond scrutiny. If the standard of public participation is allowed to fall as low as it did in this case, characterized by unverified templates, digital exclusion, and binary trap, then the Constitution promise of the will of the people becomes a dead letter. Thank you, Your Honors, for the opportunity to address you.
Thank you.
Good afternoon, my lords and my lady. I rise to highlight issue for determination E.
Your name, please.
My name is Echesa Willis. My lords and my lady, I do rise to address and highlight submissions with regard to the issue for determination number E, that is at page 11 of the issues for determination, as have been crystallized by the first petitioner. My lords and my lady, the substance of issue number E is to be found at page 51 of the first petitioner's submissions. And my lords, taking cue from the presiding judge's direction, I will not repeat what my learned colleague, Mr. Tom Masharia, has addressed the court with respect to Article 47 of the Constitution, as well as Article 50, sub-Article 1, with regard to the right to fair hearing as well as fair administrative action. My Lord, I will, for purposes of guiding the court in appreciation of this issue for determination, I will draw the court's attention to the further amended petition, specifically averments contained at paragraph 97, as well as paragraph 106. My Lord, that is the foundational essence of the issue for determination that I shall be highlighting. My Lord, further to that, I do redirect the court's attention to the affidavit in support of the petition sworn by His Excellency Rigathigachagua. My Lord, this is sworn on the 18th of October 2024. And my lords and my ladies, specific to the issue that I'm highlighting on, issue number E, my lords, I do direct the court's attention to the deposition made at paragraph 8H, that is at, it's not paginated. The next factual preposition, my lord, is the deposition made at paragraph 22. And lastly, I shall make reference to the supplementary affidavit of His Excellency Gachagua, sworn on the 27th of October 2024, specifically at paragraph 6. My lords and my lady, against the backdrop of what my learned colleagues that have made submissions ahead on the provisions of Article 47 as well as Article 50 sub-Article 1 that embody the requirement of fairness in decision-making before decision-making bodies, as has been submitted, my lord, the role of the Senate in this particular proceeding leading to the impugned impeachment, it has been submitted ably by my learned colleague, Mr. Macharia, that this was a quasi-judicial process. My lord, submissions have been made with reference to, and in this particular, at this particular juncture, I do refer to the exhibit RG1, that is, my lords, the exhibit to the supporting affidavit that annexes exhibit number 1 that starts at page 566 through to 566 through to 583. My learned colleagues did indicate that there were pre-coalition agreements, and my lord, I would urge this court to take note of the specific provisions in these coalition agreements, specifically at page 588, which is specific with regard to the reservation of the position of the Speaker of the Senate. My lord, I refer to, this is the agreement between the Kenya Kwanza Alliance Coalition and the Pamoja Africa Alliance Party. Next, my lord, is page 567 that exhibits the coalition agreement between the United Democratic Alliance and the Amani National Congress Party and Ford Kenya Party. I will redirect the court's attentions to page 578. This is at Article 21, subparagraph L and N. My lords and my lady, what those annexures, the purpose of those annexures is to amplify the fact that the speakers of both the National Assembly as well as the Senate were direct beneficiaries to the pre-coalition agreements that were in place, and that which had been submitted by the first petitioner first before the National Assembly on the 8th of October 2024 in response and in his defense with respect to ground 1 that raised the charge on the so-called shareholding issue. My lords and my lady, the point to underscore in regard to those coalition agreements is that as early as the 8th of October 2024, when the first petitioner tendered his defense to the grounds that were purportedly moved by the National Assembly, it was clear that part of the evidence that the first petitioner was to present implicated or showed the involvement and the interest of the Speaker of the National Assembly. However, my lords and my lady, the Speaker of the National Assembly did not deem it fit to recuse himself, noting that the issue of his interest would play out in the defense of His Excellency Rigathigachagua. Further to this, when the motion was or reasonably believed that it was seen by the then Speaker of the National Assembly, the Speaker of the Senate, that the coalition agreement that begot him his speakership was also in question, as it had been brought up by the first petitioner in his defense of ground 1 that had been then passed by the National Assembly. In summing up, my lords and my lady, impartiality is essential for decision making, and as my learned colleagues have indicated, the process demonstrated what my senior counsel, Mr. Ongoya, has referred to as malicious compliance, breakneck speed with regard to the moving of the motion, as well as the directions, as well as interpretation that was given to various provisions of the Constitution by both the Speaker of the National Assembly and that of the Senate. In summing up, my lord, the petitioner has, in his bundle of digest and bundle of authorities, made reference to the decision of Njiru and 11 others versus Kenya Kwanza Coalition and 18 others, which my learned colleague, Mr. Macharia, made reference to, I do urge your lordships and your ladyship, when this court retires to deliberate on the ruling, on the judgment, to be guided by the 3 judges in holding number 20 and 21 of that decision. I do submit that those 2 holdings are on all fours on the submission in relation to Article E before this court. So the issue for determination at E before the court. And in closing, my Lord, with reference to the issue for determination whether or not the speakers of both the National Assembly and that of the Senate were neutral, I do invite this court to do what the court recommended in the decision of Philip K. Tunoi and another versus the Judicial Service Commission and another, it's a 2016 decision, where the court held that in determining the existence or otherwise of bias, the test to be applied is that of a fair-minded and informed observer who will adopt a balanced approach and will neither be complacent nor be unduly sensitive or suspicious in determining whether or not there is a real possibility of bias. I do invite this court to apply that test. And my lords and your ladyship, based on what has been presented by the petitioner, we do submit and urge the court to find issue number E in the affirmative. I'm much obliged.
Thank you.
May it please your lordships and your ladyship, my name is Faith Waigwa for the first petitioner. My lord, I shall be addressing you on issue G. Issue G is the second last issue framed by the first petitioner and speaks to the invalidity of National Assembly Standing Order number 64. To start off, my lord, at paragraph 147 of the first petitioner's submissions, dated 7th October 2025, we did highlight the issue as National Assembly Order number 46 as opposed to 64. So we wish to correct that now. The body of the paragraph speaks to the correct provision, which is 64. It's just the heading that there was a spelling mistake. My lord, the question we pose on this issue is, can an internal procedure of Parliament, internal procedure rule of Parliament, namely the National Assembly Standing Order 64, constitutionally compress an impeachment process of the magnitude where a deputy president is being removed into timelines so short that they effectively extinguish the constitutional duty to facilitate meaningful public participation? My learned colleagues and seniors have ably submitted on the issue of public participation, but I'll try as much as possible not to repeat, though, my lords, you'll allow me to demonstrate why this particular provision of the standing order goes against the constitution provisions of public participation. And to that extent, we will be answering our question in the negative. And towards the end, we will invite you, my lords and my lady, to find that that standing order 64, 2 in specific, and to the extent relevant, 64.6 are unconstitutional, null and void to the extent that they impose timelines whose purpose and effect is to undermine Article 10 of the national values, Article 118 on participation by the public, Article 1 on sovereignty, Article 2 and Article 124 of the Constitution. My Lord, this is not an attack on parliamentary autonomy. It is a defense of constitutional supremacy, and we proceed to demonstrate as follows. A procedural rule that makes meaningful public participation impossible is itself unconstitutional, however neatly drafted. The vice in Standing Order 64 is not merely that it provides timelines. The problem is that those timelines are constitutionally disabling. And I will demonstrate what Standing Order 64 provides. It requires, 1, the National Assembly's Speaker to dispose of an impeachment motion within 3 days of its notification. Thereafter, it provides the disposal of the impeachment motion by the National Assembly within a period of only 7 days. We have 339 members of the National Assembly who are supposed to dispose of the impeachment motion within 7 days. And lastly, it provides for transmission of the resolution of the National Assembly once they've passed the motion to the Senate within 2 days. The real vice falls under under Standing Order 64-2, where the National Assembly has only 7 days within which to dispose of the impeachment motion. This standing order compresses a matter involving reversal of several sovereign electoral choice into 12 days, thereby making meaningful public participation illusory. And where participation becomes illusory, Articles 10 on participation of the people being a national value and principle of governance is affected. And Article 118 on public access and participation is also affected. Article 2, my Lord, of the Constitution is supreme. Anything inconsistent with it is void. The standing orders themselves derive their authority under Article 124 of the Constitution, and therefore they do not sit above the Constitution and cannot cut down constitutional obligations. The Supreme Court in Mate and another versus Wambora and another 2017, the court held as follows. Courts have jurisdiction to interrogate even parliamentary standing orders for constitutional compliance. So this principle, my lords and my lady, answers any argument by the respondents of non-justiciability. This honorable court is being invited to supervise parliamentary politics. It is being invited to perform its constitutional duty of reviewing constitutionality. My lords and my lady, constitutionality is judged not only by text, but by purpose and effect. So we look at what is the purpose of Standing Order number 64-2. Its purpose is to force expedited disposal of impeachment motions. But what is its effect? In reverse, to restrict Parliament ability to facilitate meaningful public participation in the impeachment proceedings. With this, Standing Order number 64-2 has a purpose and effect that undermines constitutional rights and national values and principles of governance, and therefore should be found to be invalid. The petitioner specifically pleads this at paragraph 98 of its further amended petition. And that is the vice before this honorable court. My lords and my lady, impeachment is not ordinary parliament business, and that has been admitted by the respondents when they say impeachment is not necessarily a legislative process. It seeks removal of a directly elected constitutional office holder, and in practical terms, revisits the sovereign will expressed at the ballot. It is that serious. Such a process demands heightened constitutional safeguards, not reduced ones, like we have seen in Standing Order number 64. Yet Standing Order 64 does exactly the opposite, my lord. That inversion should then be found to be unconstitutional. My lord, I won't repeat what has been submitted before you on public participation. However, you've heard clearly that public participation conducted on the 4th and 5th of October 2024 did not meet the threshold of the principles laid out in the BAT case. This is the British American Tobacco Kenya PLC versus Cabinet Secretary of the Ministry of Health. And allow me to just point out what violations were made. And had we had more time, had the National Assembly provided for more time in its standing orders, perhaps they would have averted these particular violations. One, Mr. Swanya indicated of the no reasonable notice was issued. A notice of extension of public participation was issued on the 5th of October 2024, which was the last day and D-Day for public participation. There was no reasonable notice whatsoever. There was no informed participation. The people of Kenya were provided with information that was minus the defense by the first petitioner, where they had one-sided story for them to consider whether to impeach or not to impeach the second deputy president. There was no balanced influence. We've heard clearly that at Bomas of Kenya, participants were actually told that the forum was for invited members of the Orange Democratic Movement. That's ODM party. Members of parliament swayed participants during this engagement. We've heard that. Therefore, the process was partisan and violates the requirement of balanced influence. We've also heard of the no integrity or transparency because forms were unverified and cannot still be verified to date. No serial numbers on those forms that were used for public participation. No methodology was disclosed. And statistical anomalies such as 162.78% support in KO South was reported. Clearly, we will all agree that this speaks to constitutional fraud. Again, my lord, I reiterate, if the National Assembly had more than the 7 days required to dispose of this notice, this motion, impeachment motion, then perhaps these violations would have been averted. The respondents may argue timelines alone do not invalidate a process. However, our response would be not every short timeline is unconstitutional. So we might agree. But a timeline becomes unconstitutional where it makes constitutional compliance impossible. And that is the case with Standing Order number 64. Why do we say the timelines there are unreasonable? First, it allows no genuine civic education before participation, because the public participation was conducted by National Assembly. Second, it allows no adequate dissemination of relevant information across 290 counties. Third, it allows no serious compilation, analysis, and debate on public views, and violates procedural fairness. The fact that the defense of the first petitioner was never disseminated to the public to make an informed decision, that process was unfair. My Lord, allow me to compare these timelines with those of the presidential election petition. We all know and understand that a presidential election petition is filed by a person who has arguably lost a presidential election. This petition is supposed to be heard and determined within 14 days by a 7-judge bench. In contrast, when removing the same president who's been confirmed perhaps in the presidential petition, the National Assembly allocates itself only 7 days to remove a president or a deputy president who was validly elected using universal suffrage, and the people sitting to remove the president or the deputy president are 349 members of the National Assembly against only 7 judges at the Supreme Court when hearing and determining an election petition. My lords, there is a problem. That removal has to be extremely fast, but confirming can have more time. Confirming a president can have more time, but the removal of such a president or deputy president must be extremely fast. My lords and my lady, I'll draw some comparatives from parliamentary systems of government, which my learned colleague, Ochiel Dudley, was able to bring to your attention. We did the research with him. In Nigeria, the timelines are 4 to 5 months. 4 to 5 months for the entire process. In Kenya, the process is around 2 weeks to 4 weeks maximum. In South Korea, Constitutional Court is given up to 180 days to render its determination. In the US, my lords and my lady, we will be surprised that there are no rigid timetable. But historically, what has been happening is around 2 months or more. And the reason is that the flexibility exists because of the gravity of such matters that demand deliberation. So you will find from the countries we've drawn your attention to is that they are more of an investigative process as opposed to a mob justice process that took place in our country at the National Assembly. Why are we comparing this? This comparative material is not cited to import foreign constitutions. it is cited to illuminate a constitutional principle. Basically, Kenya is an outlier when it comes to timelines for removal of its president or its deputy president. Where removal overturns a popular mandate, constitutional democracies favor deliberation, investigation, and participatory legitimacy, not speed. I repeat, my lords, not speed. So the Kenya's National Assembly Standing Order 64 runs opposite to this democratic pattern. Article 124 creates standing orders as subordinate procedural instruments. Being subordinate procedural instruments, they therefore cannot dilute Article 10 on participation of the people as a national value and principle of governance. They cannot dilute Article 118 on public access and participation. They cannot dilute Article 1 on sovereignty of the people. They cannot dilute Article 47 on fairness in administrative actions and quasi-judicial outcomes and decision. My lord, they cannot dilute Article 50 on fair hearing and Article 2 on the supremacy of the Constitution. As I conclude, my lord, constitutional obligations are not optional where timelines are tight. If timelines make it impossible, then those timelines must yield, not the Constitution to yield. My lords and my lady, would want you to look at expediting the process as a value, but participation of the people should be looked at as a constitutional command. When they conflict, then the Constitution prevails. We respectfully invite this Honorable Court to hold that the National Assembly Standing Order 64-2, and to the extent inconsistent Standing Order 64-6, why we say so, my lady and my lords, is because the 2-day timelines is provided in the Constitution. That is what has been captured under Standing Order 64-6. Violate Articles 10, 118, 1, 2, and 124. If you find favor with our prayer, then Standing Order 64, 2 and 6 should then be found to be invalid for being unconstitutional. My lady and my lords, as you retire to write your judgment, we need to answer to this question. We kindly request that you address yourselves to, can sovereign will expressed through election be reversed through a process too hurried, like that at the National Assembly, having been given 7 days, for the people to meaningfully participate in it? We look forward to a respectful answer of no. And for these reasons, we respectfully urge this Honorable Court to declare the Standing Order 64.2 and 64.6 as unconstitutional, null and void, to the extent they impose timelines whose purpose and effect is to undermine the articles that are mentioned, 10, 118, 1, 2, and 124 of the Constitution. I so respectfully submit. Thank you.
Thank you.
My Lord and my lady, my name is Njomo John, appearing for the first petition of my colleagues, and I'll pick up from where my learned colleague Faith Waigo has left. I rise to briefly submit on the reliefs that the first petitioner is seeking before you. I know counsel who has submitted before me have mentioned variously part of what I'm submitting on, and that is the reason why I will not take long. My Lord, when this court delivered its ruling on the 31st of October last year, I want to refer to paragraph 158, being the background under which the first petitioner is before you. He's literally in court today. You know, there were worries as to what the court would do in the outcome of an impeachment and election or nomination of a deputy president in replacement of the second deputy president. And this is what the court said. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience. Moreover, the Honorable Attorney General, through Senior Counsel Githu Muigai, has given an undertaking to comply fully with any orders that this court, any orders issued by this court in this matter. So that when we come before you, this court has an open page. All the reliefs that the petitioner is seeking are grantable by the court, because even Professor Githu Muigai, it's on record that he has given an undertaking that there will be full compliance. So that, my Lord, the reliefs that the first petitioner is seeking are captured at paragraph 148 all through to paragraph 148 of the submissions. This is appearing at page 61 of the submissions by the first petitioner. Page 61. That is prayer number H. What are the appropriate reliefs? Starting from paragraph 148, running all the way to paragraph 152. And Your Honor, there has been various mentions of the issue of public participation. I want to address the prayer relief number 1, that is A, a declaration that the respondents have contravened the provisions of Article 10 and Article 118(1) of the Constitution by initiating a process leading to the removal of office by impeachment against the petitioner. My Lord, relevant to that particular prayer is the definition of what Parliament is at Article 93 of the Constitution. And this is what it says. There is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. And very briefly, my Lord, we have been told there was some semblance of public participation conducted by the National Assembly. But on record, nothing has been demonstrated or rather the respondents, especially the Senate, has not given any indication that there was any semblance of public participation. The reason why I'm saying this is because Parliament is both the National Assembly and the Senate. Even if there was some public participation initiated by the National Assembly, there was none whatsoever that was initiated by the Senate. This is the reason why we are saying that there is violation of Article 118(1) of the Constitution, because the Constitution requires that Parliament shall conduct business in an open manner, and in its sitting and those of its committees shall be open to the public. It goes further to say that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So that then the question is, what happens when the Senate conducts its business without involving public participation, without invoking public participation? The answer can only be that there is a clear violation of Article 118(1) of the Constitution, and we pray that then the court finds that in favor of the petitioner. My lords and my lady, we have gone to pray for a declaration under B. I don't have to read the whole of it, but it has been explained by counsel that some of the charges that were confirmed against the first petitioner, there was multiplicity and duplicity of charges. That you have allegations and particulars being referred to in support of a given allegation. So that then what we pray under a declaration that we are seeking under B, motion lacks the particularization and specificity required by Article 145(1) of the Constitution. This is important because it was submitted by Senior Counsel Ongoya, and he explained in detail how the charges 3, 4, and 5, particulars that were relied upon were in particulars or the charges in A and B, charge 1 and B, so that there were no particulars in support of those other allegations. The next prayer that the petitioner is seeking is as regards the inconsistent and violation of the Constitution under B, a declaration that the resolution passed on the 8th of October 2024 by the National Assembly to impeach the petitioner pursuant to the provisions of Article 145 and 150, and the communication dated 8th October 2024 sent by the Clerk of the National Assembly to the Senate titled that are both founded on a process that is inconsistent and in violation of the Constitution of Kenya. The reason why this prayer is being sought, my lords and my lady, is for the reason that there were many inadequacies resulting to the impeachment process, both at the National Assembly and the Senate. So that the culmination of it is that the process was a sham, and whatever that resulted from that particular process cannot sustain the impeachment process. So that we pray that the court can grant prayer number C as sought in the amended petition. My Lord, we also sought a declaration that for the purpose of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. My lords, the background on this is that the election of the Deputy President and the President takes place at the polling station. Counsel who has submitted before me have explained to my lords that the initial notice that was given was that public participation was to be undertaken at the county level. Subsequent communication was that there will be public participation at the constituency level, without an indication as to where the venue and more details to allow members of the public to meaningfully participate in public participation so that they can give their views. So that without a clear communication that public participation was to take place in all the 290 electoral constituencies and the 1,450 electoral wards, then that process cannot be said to have met the constitutional threshold on meaningful public participation. It is for that reason then that, my lords, we pray that you can find in favor of the first petitioner the declaration that is seeking under D. The subsequent declaration is on the timeline that was given, a declaration that the 12-week period provided under standing order 64.2 and 64.6 of the standing orders of the National Assembly is grossly insufficient. My lords, I will not repeat that because Council Faith Waigua has elaborated on the inadequacies and the prayer to have the same declared unconstitutional. Subsequent to that, my lord, we have prayer number F. Most of those others I'll consolidate. A declaration that the proceeding before the whole House plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited to time-bound 10 days. This is, my lord, what Ochiel Dudley explained, that the 10 days that the Senate imposed on itself was not, did not have any legal basis, so that it was not justifiable for the Senate to impose itself on a 10-day period to conclude the business in a very rushed manner. As it was indicated by the Speaker of the Senate, they wanted to do that with military precision so that they could attain a premeditated outcome in our submission. My lord, prayer number G is a declaration that the petitioner's right for fair administrative action under Article 47, a right to fair hearing under Article 50 of the Constitution were violated. My lord, it has been explained in detail how the first petitioner was denied a fair hearing, so that even at a point when he fell ill, it was communicated to the Senate, and Senior Counsel Paul Muite explained to the Senate the circumstances under which he was not able to proceed with the hearing before the Senate. The Senate proceeded, regardless of that particular communication, to proceed with the impeachment process. So that is a very clear indication that the process was not fair, and the rights of His Excellency Rigathigachagua under Article 50 were violated to the fullest. My lord, declaration number H that we're seeking is that the National Assembly and the Senate, in their evaluation of the impeachment proceeding before them, failed to properly assess each of the specified ground and determine if they collectively and individually constituted gross violation of the Constitution. My lord, it has been explained to you again that even where a provision of the law has been declared unconstitutional, the National Assembly and the Senate still proceeded to find and uphold those particular allegations. The aliquots have been explained, and the court has been taken through the process leading to the invalidation and declaration of the unconstitutional provision under that particular act. But nevertheless, the National Assembly did not consider it necessary to find that some of those allegations were even illegal, were unfounded, and could not stand the test of law. Next to that is an order that this court quashes several documents and communication. I will not read each and every order, but we have sought orders of certiorari to remove and quash the communication of 8th of October 2024, 17th of October 2024, resolving to remove the office from office by impeachment His Excellency Rigathi Gachagua as the Deputy President of the Republic of Kenya. The reason for this, my lord, is, as explained before, that there were legal illegalities that were committed along the way, and these particular notices of 8th of October and 17th of October were the culmination of those particular illegal proceedings, so that the only justifiable cause that the court can give is to quash the notices of 8th of October and 17th of October 2024, respectively. Subsequent to that, there is also a request or a prayer that the notice by the Senate of 17th of October be quashed. This is the notice communicating the impeachment of His Excellency Rigathi Gachagua to the National Assembly. My lord, we have then all the other prayers that we have sought. And my lord, by the time someone is being elected to to the office of the Deputy President or any other office, the expectations that come with it. We have given an authority that this court can award damages where there are violations of the Constitution. This is the case of Manyora versus Republic, where the court held that where there are violations of the Constitution, and this is at paragraph 151 of our submissions. My Lord, you'll have a chance to look at it. The case of Manyora and two others versus the AG, 2016 Kenya Law Reports, that where the court said that award of damages for constitutional violations of an individual's right by state or government are reliefs under public law remedies within the discretion of the court. So that at paragraph O of our prayers, the first petitioner has come before you and is praying for general damages, punitive and aggravated damages. These are not far-fetched because the court has previously found that they are awardable by the court, because if we have demonstrated to the court that his rights were violated, then the court can award damages as prayed under paragraph 01 of our submissions. My Lord, we have also explained in detail that he was earning a salary that maybe I don't have to give a figure because there's a lot of calculations, mathematical calculations, but you will have a look at paragraph O, where we have listed the benefits that the Deputy President was earning, what he was entitled to, and what his salary could have been if he worked for the 5 years that the Kenyan people had given him a mandate. So that we have therefore calculated those particular salary expectations and benefits that he was entitled to under the law. And we pray that the court can allow and award those particular prayers as sought. My Lord, the office of the Deputy President attracts some benefits, again, other than the salaries, which we have enumerated under paragraph P, because there are quite a number, including quite a number of issues, cleaners, gardeners, and all that. I believe that my lords will have a chance to look at those particular prayers and the allowances that he could have been entitled to, could he have served his full 5-year term. We do have the play that the court will allow the prayers as sought, and I believe you'll have a chance to have a look at all of them in detail, one by one, in awarding and agreeing to allow the petition as prayed. I think, Mr. Mashari, you have a word to mention about it.
I just wanted to remind my colleague that he needed to emphasize that most fundamental matter called costs. We need costs on behalf of the Deputy President for all these bad things that have been done to him and to us. Thank you very much, my lords.
Well, that concludes the highlighting on behalf of the first petitioner. We thank you.
Thank you. I see Dr. Gada standing up.
Yes, Your Lordship.
You said you wanted 2 hours, huh?
Not 2 hours. We will be done in an hour less. Myself and my brother Sakim.
Hello?
We'll come.
Well, Lord, we are yet to address the court for the 44th to 49th.
I'm also present on behalf of the second petitioner. So I don't know if I will be able to address today or the other day. Oh, my name is Teresia Wanjiru Kimoto of Tess Kimoto and Company Advocates Kerugoya.
my lords, if I may, just for a minute.
Yes.
I'm not objecting to test. My lord, in terms of equality of arms, I am concerned that the petitioners, having had 5 hours, and the other parties having the possibility of attacking another 1 hour or 2 hours, would then mean the respondent then would have, in terms of equality of arms, we then need the same amount of time in responding. And you had given 6 hours previously. So perhaps I suggest that Evans Ogada, the professor, together with the other petitioners, then share the 1 hour so that we are equal, so that we don't go outside the 6 hours. Test can take 20 minutes so that we...
Why me 20 minutes?
I think my learned friend, Professor Tom Ojienda, is being anticipatory. Let him wait and see perhaps how long we take. Then he can say at that time how much time he wants, rather than trying to, put the court in some straitjacket. We are very grateful, those appearing for the first respondent, but I do plead that the other counsel appearing for the other petitioners have their day in court.
We are in court.
Yes.
We are in court. They are having their day.
They have their day.
Yes.
They have their day in court.
Yes.
Because what this honorable court will ultimately say, either way, is going to apply in future.
I think the only issue we need to address is how much time do we give them? And I think we should appreciate that we don't have all the time. So let us plan to share maximum of 1.5 hours.
Your Lordship, I'm sorry, but I'm constrained to object to that approach. When we had the hearing for the conservatory orders, we restrained ourselves and took our and allowed the court to limit our time. But I think for the petition, let us have sufficient time to ventilate on all the issues. We shall take the least amount of time possible. But if you say 1 hour and a half, and Dr. Ogada is coming up, I do not know how much time you will have to for the rest of us.
I think we are wasting time. Let's proceed. We'll see how far we'll go.
Good afternoon, Your Lordship, Your Ladyship. I appear alongside my brother, Mr. Sakimpa. We appear on behalf of the 4th to the 8th petitioners. Ab initio, we will be relying on the following documents. We will be relying on the petition dated 18th October 2024, the affidavits in support sworn on 18th October, the written submissions dated 16th January 2026, the list and bundle of authorities dated 16th January 2026, the further list of authorities that dated 25th April 2026. All power has a limit. All power has a limit. Certain values in the Constitution have been designated as foundational to our democracy. This in turn means that as pillar stones of this democracy, they must be observed scrupulously. If these values are not observed and their precepts are not carried out conscientiously, we have a recipe for constitutional crisis of great magnitude. In a state predicated on a desire to maintain the rule of law, it is imperative that one and all should be driven by a moral obligation to ensure the continued survival of our democracy. That is a paragraph from Nyathi versus member of the Executive Council for the Department of Health, Gauteng, and another 2008, Madala J at paragraph 80. It's in our list of authorities supplied, dated 25th of April 2026. My good friend, Elisha Ongoya, wandered in the morning, and I joined him in the wandering. Which way Kenya? What is the state of our morality in terms of our constitution? We have provided a case, and that case will form my next line of submission, the case of EFF, Economic Freedom Fighters versus National Assembly, 2018 South African Constitutional Court. Which way for Kenya? The first petitioner has gone through what happened in terms of the process. It paints to us a very worrying state in terms of the health of the democracy that we have in this country called Kenya. This is a clawback in terms of the Constitution and the state of our democracy, culminating into the Constitution 2010 that was characterized by huge cost for the ordinary Kenyans. People shed blood, people were killed, and people died. We should not lose focus of that. And that state of affairs painted by the first petitioner leads me to pose this question to the court. Did we need specialized rules and procedures for this process of investigations and hearings to be established before the process commenced? Did we need specialized rules and procedures before the process of impeachment investigations and hearings commenced? That is a question, your lordships, your ladyship, this court must answer. And like my elder senior counsel, Elisha Ongoya, I'm relishing to read the answer to that question from this court. On our part, we respond in the affirmative. Yes, we must, and we needed to have specialized rules before the impeachment began, either in form of a specialized code, or it ought to have been mutually agreed between the parties. Parliament ought to have sat down with the Deputy President and agreed on the rules of procedure, or else we should have had a specialized code. For the following reasons. Number one, protection of constitutionalism and the rule of law. Pre-established rules ensure the impeachment follows constitutional norms rather than political convenience or sudden improvisation. The Speaker extends it to Saturday. Parliament says no. We will do as we wish. Error. Kosa kubwa. Secondly, prevents abuse of power and political witch hunts. Clear procedures make it harder to weaponize impeachment and partisan revenge for short-term political gain. Number three, guarantees of fairness and due process. The office holder facing impeachment deserves predictable procedures, notice of charges, a right to respond, and an impartial hearing. Number four, enhances legitimacy and public confidence. When procedures exist beforehand, the public is more likely to trust the outcome as lawful and not pre-engineered. Public trust, public confidence. Next, it ensures institutional consistency. Preset rules prevent changing procedures mid-process to suit the circumstances or the person under investigation. We are giving you, was it 10 days? Then midstream, we are going to continue, irrespective of whether you are sick or not. Rule of law questions. Can we operate a serious constitutional interrogation such as an impeachment in that manner? No, we say. promotes separation of powers. Structured procedures reduce institutional conflict by clarifying the roles of parliament, courts, and other bodies. Number 7, provides clarity and efficiency. Investigations and hearings move faster, are more coherent when procedural uncertainty is removed. Number 8, protects minority and dissenting voices. Those that dissent, and for aught we know, perhaps we had dissenters, people who are willing to vote against the impeachment. We may never know because the rules lacked. Formal rules ensure minority members in legislative bodies can participate meaningfully and are not outshot by majorities. It creates objective evidentiary standards. We had objective evidentiary standards from the courts. If that was applied in Parliament, that we don't know. But if that was agreed to in terms of rules, we will know what we are facing in terms of what evidentiary standard are we going to abide with. Finally, it builds a stable constitutional precedent. A predictable framework helps future impeachment processes remain consistent, credible, and less destabilizing to governance. A stable constitutional precedent can only emerge where constitutional values are treated as binding rules rather than aspirational rhetoric. If foundational values of the Constitution are understood as enforceable obligations, they naturally demand structured, predictable procedures whenever the most serious constitutional powers, such as impeachment, are exercised. In this way, fidelity to constitutional values become the anchor for consistency, ensuring that future impeachment processes are guided by principle instead of political expediency, and that governance remains stable, credible, and firmly rooted in the rule of law. The reasons for a rule-based impeachment process. There are no rules. In terms of the constitutional values at play, this court is going to make a decision for expediency. This is not just any other decision. Constitutional values are not decorative. They are not mere suggestions on the walls. They are binding obligations. These are our pillar stones, and these values that we have in the Constitution, such as the rule of law, due process, constitutionalism, accountability, transparency, separation of powers, are a must. They are inextricable. So when impeachment procedures occur without procedural law, clear procedural law, Parliament is no longer implementing the Constitution. It is operating outside it. And I dare confidently, with all the strength from my ancestors from Nyahera in Kisumu, say this, that impeachment is not a political ritual. It is a constitutional trial. May I repeat this for members of the National Assembly? My senator from Kisumu is here. Impeachment is not a political ritual. It is a constitutional trial. So without procedure, the process becomes arbitrary, and this directly undermines constitutional supremacy. That is one. Number two, the rule of law requires procedure. Power cannot operate in a vacuum. The rule of law means that power must be exercised through known, predictable, and fair procedures. We are extending time for you till Saturday. No, we are continuing with the impeachment immediately, irrespective of whether you're present or not. That is rule by man, not rule of law. Failure to have procedural law in the context of this impeachment meant this, that we did not have clear, predictable rules of evidence. That is one. The burden of proof, if at all it existed, kept on being a moving target. There was no right of defense. It was never guaranteed in the first place. People wanted to finish with what they wanted to do and move on. There are no clarity in terms of timelines, fairness, or impartiality. This creates a dangerous precedent where decisions depend on political discretion, not law. The process becomes rule by numbers, not rule of law. And in constitutional theory, absence of procedure means absence of legality. May I repeat that? Absence of procedure means absence of legality. Number 3, impeachment is a quasi-judicial process, not a political vote. That term quasi-judicial has been used a lot here. But what is exactly meant by quasi-judicial? In my other life, I'm a member of the academy, and I see two senior members of the academy here. They can confirm that, and may God bless them in advance. Professor Jenda, Professor Gido Muigai, senior members of the academy. Quasi-judicial power means this, that this is the power to determine disputes or making findings affecting the rights of individuals, similar to the way courts operate. What was at stake during the impeachment? A validly elected deputy president of the republic was going to be impeached. His rights personally and the rights of his many supporters, those who voted for him as part of a ticket, were going to be affected. The consequences are there in terms of the quasi-judicial power. The removal of a deputy president being a very serious constitutional action. It has consequences for the electoral will of millions of voters, stability of the executive, continuity of government. And because of this gravity, impeachment must meet quasi-judicial standards. Quasi-judicial standards, these are the principles of good governance. I don't want to go through the whole list, but again, members of the academy, Professor Don Oliver has reduced the principles of good governance into 4. Very quickly, these are legality, procedural propriety, rationality, and proportionality. The Oliverian quadrant: legality, procedural propriety, rationality, proportionality. When this court retires, we pray that you are going to consider those 4 principles. This process, as has been brought out by the first petitioner, do they meet the tests of legality? Do they meet procedural propriety in whatever guise? Does it mean rationality? Again, Professor Jenda should be familiar with Wednesbury degree rationality. That's a test.
Counsel, address the court, not the academy.
Most obliged. Most obliged. Most obliged. If I veer into the academy, please forgive me. Most of the time, I veer towards the academy. Wednesbury rationality. Has the Wednesbury rationality test been met in terms of this particular impeachment process? Proportionality. Look at the allegation on, for example, what was said and what ought to have been referred to the NCIC, the National Cohesion Committee. Was that proportional? Does it meet the proportionality test? And on that very issue, Senior Counsel Paul Buite submitted to it. There's the principle of subsidiarity that is captured under Section 15 and Section 26 of the NCIC Act. Parliament ought to have deferred to the authority of the NCIC on the allegations made against the Deputy President. NCIC ought to have made the primary decision on the gravity or lack thereof of what was said. So the assumption of Parliament without going to the NCIC is not only illegal and unconstitutional, it also offends the principle of subsidiarity. When Parliament conducted itself in the manner it conducted itself, Parliament acted as the Hobbesian Leviathan. It became the investigator, the prosecutor, the judge, and the jury. This violates Article 47, principles of fair administrative action, and judicial action, quasi-judicial action. Procedural fairness protects the people, not just the office holder. Impeachment is often framed as an accountability of one individual, but constitutionally, impeachment protects the voters who elected that office holder. If procedure is absent or conducted in the manner it was conducted in this case, the electorate's choice can be overturned by unregulated political processes. This weakens popular sovereignty, a core constitutional value. Thus, the real victim of procedural failure is democracy itself. Whereas it protects, there are protections for the individual, the real protected target is the core principle of popular sovereignty. 5, the absence of procedure invites a constitutional crisis. Why? Because without procedure, courts are forced to intervene, parliaments claim political privilege, the executive legitimacy becomes contested. We have a deputy president who did not come through the ballot. That's a legitimate question. Institutional conflict arises between the arms of government. And this leads to the usual talk, judicialization of politics, politicization of constitutional processes, public loss in institutions. A constitutional democracy cannot survive when removal of national executive and office holders lack legitimate legal guardrails. 6, separation of powers demands legal boundaries. Parliament has the power to impeach, but not without limits. Parliament becomes a judge in its own course without procedural law. Checks and balances collapse. Majority power replaces constitutional restraint. Remember, we are a state under constitutional restraint, not abundant political power. The way in which this impeachment process was conducted contradicts the idea that constitutional supremacy restrains political majority. That is something we will invite you to find. The rules of natural justice, there are 3. The right to be heard, freedom from bias, and those have been submitted to. Then there's the 3rd rule, the rule in Republic R versus Sussex, Justices Ex parte McCarthy, 1924. And this rule, as articulated by Lord Justice Hewitt, simply says this, that justice must not only be done, but manifestly and undoubtedly it must be done. Justice must not only be done, but manifestly and undoubtedly it must be seen to be done. In terms of this process of impeachment, the processes continued when the substantive subject of impeachment was in hospital. He did not have the opportunity to rebut or to respond to the charges. In terms of the 3rd rule, the first 2 were submitted to. I focus on the 3rd rule. R versus Sussex Justice Magistrates. Justice must not only be done, but must be seen to be done. Do we see justice to have been done in this context when somebody was sick in hospital and processes continue without him being present? It's a problem. Precedent danger. Today's deputy president, tomorrow's democracy. If impeachment can continue and happen in such a shambolic manner that it happened, future removals will be done and can be done more easily. The threshold for removing elected leaders becomes political convenience. My brother Ochiel gave us the history. I don't want to go through it. Political convenience brought us to where we are in terms of shielding the office of deputy president. Executive stability becomes fragile. This transforms impeachment from a constitutional safeguard into a political weapon. Is that what we want in terms of this court? In terms of the jurisdiction of this court, I have completed with the rules of procedure. I want to go to the jurisdiction of this court. The High Court has 4 jurisdictional capacities under Article 165. The High Court has original jurisdiction, appellate jurisdiction, supervisory jurisdiction, and writ jurisdiction under Article 165. At play, particularly with regards to the matters before this Honorable Court, are the supervisory jurisdiction and the writ jurisdiction of this court. The supervisory jurisdiction becomes particularly important under Article 165(6) when supervising quasi-jurisdictional capacity of various arms of government. And this is where the court will invoke its judicial review power or judicial review authority. What is judicial review? Judicial review has 2 limbs to it. Judicial review is the primary judicial function to preserve legal order by confining the political branches to their proper limits of power under the Constitution. That's the first limb. The second limb is protection of private individuals by preserving or preventing illegal encroachment on the rights of these individuals. Those are the 2 capacities of judicial review. And when the High Court, under Article 165 of this Constitution, stands as the primary guardian and interpreter of the Constitution and its values, the court exercises broad authoritative jurisdiction, including supervisory and constitutional oversight over the National Assembly, so that the National Assembly will not be had to say that this is a political question beyond the reach of the court. This court, the breadth of its constitutional and supervisory jurisdiction is a capacity granted by the Constitution, and it's not an intrusion into the domain of the legislature, and is a necessary feature of constitutional design. I hear telepathically, and I can almost predict that you will hear this from the respondents, that Parliament has its right to formulate its own procedures. If the courts will be inclined to find it that way, we have provided to you a case, Maneka Gandhi versus Union of India, 1978. And it presents to this court a test. The Supreme Court of India, interpreting Article 21 of the Indian Constitution, speaks of due process in this manner. It says, number 1, that procedure as a capacity of due process must be established by valid law. That is condition precedent. That condition adds on to say that even if the procedure is prescribed by law, it should be fair, just, and reasonable. Fair, just, and reasonable. So when you retire to write your judgment and you are satisfied that there was a modicum of procedure, you will have to look at that procedure in terms of the Maneka test. Was that procedure fair? Was it just? Was it reasonable? Was it reasonable to continue with the process when somebody is at the current hospital getting treatment? That is a question you will have to answer. In conclusion, a determination of impeachment is not a routine judicial exercise. It lies at the crossroads of law, constitutional governance, and the stability of democracy itself. La santé de notre politique, as the French say. The stability of democracy itself. The court's voice in this moment is not confined to the litigants before it, but resonates to the nation and future generations. This is a modern moment. Your judgment will either confirm that constitutional authority is bound by the discipline of law, or suggest that the most serious constitutional processes may unfold without the safeguards of the Constitution as required. By carrying out this solemn responsibility, the court protects the supremacy of the Constitution, sustains public confidence in democratic institutions, and ensures that the exceptional power to remove a constitutional office holder is exercised strictly within the confines of the rule of law. Nunca más, never again, should we go to the dark old ages. I submit. My brother Sakimpa joins in next.
Thank you.
Yes, Your Lordships and my lady, my name is George Sakimpa. We do appear together with Mr. Ogada for the 4th to 8th petitioners. Your Lordship, the petition that is before you is originally Kerugoya petition E015, and which has since been consolidated in these petitions. So, Your Lordship, I will only deal with 2 issues, because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle 2 issues, the first one being on the element of public participation, and it is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate, and whether it was open for the Senate to apply the plenary route. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently espoused here, especially the BAT Supreme Court case. So, Your Lordship, I will not delve into that, other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of BAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in these short submissions is to go to the evidence and to actually demonstrate that the public participation exercise that was conducted on 4th and 5th of October 2024 were neither qualitative nor quantitative. So, Your Lordship, I will begin with the affidavit that was sworn by the 4th petitioner, that is Honorable David Munyi Madenge, where, Your Lordship, in that affidavit, he says that he had no opportunity at all to participate in terms of echoing the views. And what was the reason for his inability to air his views? Your Lordship, the reason is that when he went to the designated center, Your Lordship, that center was closed. First of all, Your Lordship, the center was not open. It was closed, and there are evidentiary documents that were attached to his affidavit to confirm that that venue was closed. And that is what he has deponed in his affidavit, to the effect that he did not participate at all because all the residents of Kirinyaga in that instance who went to that particular station did not participate. They dispersed without having given their views in terms of the impeachment of the second deputy president. So, Your Lordship, the next issue is on the issue of the notice. Your Lordship, from the notice, especially the extension notice of public participation, that notice was pursuant to the orders that were issued by Honorable Justice Richard Mwongo in a petition that was earlier filed, and where the judge said that the modalities that were put by the National Assembly were not sufficient and therefore ordered for a second phase of public participation. So, Your Lordship, what the National Assembly did, instead of going back and preparing for a proper public participation as was ordered by the judge, they simply extended the public participation. Your Lordship, from the annexure that we filed, that is DMM1, Your Lordship, the notice is actually dated the same day when the extension was actually supposed to happen. So, from the daily newspapers that were filed, Your Lordship, it was on the very same day, that is on 5th of October 2024, telling the public that we have extended the public participation. So, Your Lordship, that notice was not enough, and even from the affidavits that was sworn by the 5th, 6th, 7th, and 8th petitioners, Your Lordship, they do confirm that they came to realize that the extension was given after, in fact, on the next day. So, in short, Your Lordship, because I don't want to repeat what my colleagues have already said, it is our humble submission that this court return a finding that indeed the notice was not sufficient for a meaningful and qualitative public participation. So, Your Lordship, on the other issue of quantitative aspect, my learned senior, Mr. Tom Masharia, had given a percentage in terms of the qualitative aspect, that out of 50 million Kenyans, only 200,000 gave their views in respect to the impeachment of the second deputy president. So, Your Lordship, that translates to 0.04%. And that is what basically said it's still 0%. So, Your Lordship, it was not quantitative and it was not qualitative. And Your Lordship, I only want to mainly emphasize on the decision that we filed, Law Society of Kenya versus National Assembly, 2025, where, of course, the court, in agreeing with the BAT case, the court said that public participation must be real. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. So, Your Lordship, I have already submitted that it was neither qualitative nor quantitative. So, Your Lordship, I want to go now to the next issue in terms of the public participation in respect to the appointment of Professor Kithure Kindiki as the Deputy President. So, Your Lordship, and I'll be referring to the memorandum that was signed by the President. And Your Lordship, we have it in page 1 of the affidavit that was sworn by Honorable David Madenge. It is page 1. So, and the document is a presidential memorandum of nomination by His Excellency the President William Ruto to the National Assembly. And it says that whereas pursuant to Article 150 of the Constitution, a vacancy has arisen in the office of the Deputy President. So, Your Lordship, in relation to that, our submission is that this nomination of Professor Kindiki was subject to the Public Appointments Parliamentary Approval Act, that is Cap 7F of the laws of Kenya. And Your Lordship, in respect to this particular act that I'm referring, the Presidential Memorandum of Nomination is substantially in compliance with the provision of this act, except on the element of public participation. That is where the National Assembly drew the line, that the memorandum of did comply substantially with the act, but they chose not to undertake public participation. And I will start with the objective of this act. So, and the act says it is an act of parliament to provide for procedures for parliamentary approval of constitutional and statutory appointments and for connected purposes. So, Your Lordship, from the memorandum by the President of nomination, it is clear that this is a constitutional appointment, because he actually says that pursuant to the provisions of Article 150, a vacancy has arisen in the office of the Deputy President. So, in essence, Your Lordship and my lady, this is a constitutional vacancy and a constitutional appointment that was subject to the provisions of the Public Appointments Parliamentary Approval Act. And Section 3 of that Act says that the exercise of powers of appointment. So an appointment under this Constitution, that is Section 3, an appointment under this Constitution or any other law for which approval of Parliament is required shall not be made unless the appointment is approved or deemed to have been approved by Parliament in accordance with this Act. So, Your Lordship, it is clear that the appointing authority in this case was the President. So after appointing Professor Kithure Kindiki as a nominee for the position of the Deputy President, it was subject to the application of this Act. And as I said, Your Lordship, the memo complied completely in all aspects with this Act, save for public participation. So, and Section 5 also provided for notification of nomination. And it says that an appointing authority shall, upon nominating a person for appointment to which this Act applies, shall notify the relevant House of Parliament. So it is through this Presidential Memorandum of Nomination that Parliament was notified of this appointment of Professor Kindiki. And it further says that a notification of appointment shall be accompanied by information concerning the nominee having regard to the issues mentioned under Section 7. So, Your Lordship, I am sure that you will have an opportunity when you retire to examine this Presidential Memorandum. And in fact, it does highlight that the President says that for reasons whereof I have enclosed the following documents, and which Senior Counsel Paul Mwite said that it was done in an ungodly speed. So, Your Lordship, I want to reiterate that the essence of this Act was provided by Parliament so that it provides safeguards, especially on the issue of public participation, where the citizens will be given an opportunity for them to give views on the new nominee. And that is the procedure even in terms of the appointment of cabinet secretaries and all the appointments that are made under the Constitution. And Section 6, which is the most important part, it says that the committee, Section 6(4), approval hearing. So the committee shall notify the public of the time and place for holding an approval hearing at least 7 days prior to the hearing. So, Your Lordship, 7 days prior to the date of the hearing. Your Lordship, of course, from what we've heard is that the impeachment was done on the 17th of October, and on the next day, that is when the President forwarded this memorandum of appointment. So, Your Lordship, from that moment, the law requires that before the approval was done, the public had to have been given a notice of at least 7 days. So, Your Lordship, and the President further says, in forwarding this nomination, that, and he quotes Article 149 of the Constitution, which says that within 14 days after a vacancy in the office of the president arises. So, Your Lordship, within 14 days, of course, this was done within a few hours. It was, the impeachment was done at night, and in the morning, the president did this act. So the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. So, Your Lordship, under Article 149, the Constitution gave 60 days for Parliament to consider the appointment of the new nominee. And the reasoning, Your Lordship, is that these documentations that have been given by the President forwarding the nominee, Parliament was under an obligation to consider those documents within a period of 60 days. Your Lordship, by midday on 18th of October, Parliament had already voted on the issue of appointment of Professor Kindiki in complete disregard of Section 6(4) that required the public was to be given at least 7 days so that they can give their issues in terms of the suitability of the Deputy President nominee. Your Lordship, but obviously that was not done. And Your Lordship, I'll also now refer to the response that the National Assembly, in their submissions, they have filed, or rather they have given a ridiculous response to these submissions that we made. And under paragraph 361 of their submissions, they say that, in fact, this was a sui generis, it was a sui generis procedure, to the effect that it was not an approval, but a vote by the National Assembly. Your Lordship, assuming even we take the argument that they say that in fact it was a vote and not an approval hearing, Your Lordship, then the provisions of Article 118 of the Constitution will then apply, because they will still need to conduct public participation as required under Article 118. And Article 118 provides that public access and participation. So it says that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So, Your Lordship, even if they escape the provisions of Section 6(4) of this Act, of the Public Appointments Parliamentary Approval Act, then they cannot circumvent the provisions of Article 118, which requires that Parliament must still, in all its businesses, involve the people. And Your Lordship, there is an authority that I want to rely on, and that is Legal Advice Center and two others. It is in our case, in a bundle of authorities, versus the County Government of Mombasa and 4 others. It's a 2018 decision. And Your Lordship, I just want to quote in verbatim a very small part where the court said that the purpose of permitting public participation in the lawmaking process is to afford the public an opportunity to influence the decision of the lawmakers. So, Your Lordship, assuming that we were to take the proposal that they said that this was a vote that ought to have been taken by the National Assembly, then under Article 118, they must have sought public participation before they made the vote to approve the Deputy President nominee. And Your Lordship, they further give a fallacious explanation and say that actually it is equal to the election of the Speaker and Deputy Speaker and members of the regional Parliament, that is IALA. So, Your Lordship, that is not true. In this case, this nominee is directly appointed by the President, and there is a memorandum of presidential appointment. In the case of a Speaker and members of the East African Legislative Assembly, they are directly elected by Parliament, or rather in whichever house that is applicable. So there is no nomination that happens by any authority in terms of before the speaker is elected. They are directly elected by the members of parliament. So, Your Lordship, the last issue that I'm going to discuss as I conclude is on the issue of whether the Senate violated Article 145 in terms of taking the plenary route. Your Lordship, our submission is that it was not open in law for the Senate to take the approach of the plenary. And my learned senior Ochiel Dudley had already discussed Article 145.3. So, Your Lordship, I will not belabor on that point, other than to submit that under that provision, that is Article 145.3, where it says that the Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President, and the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. So, Your Lordship, even if we were to apply all the statutory, or rather all the interpretations, rules of interpretations of the Constitution, all of them will point to the position that the appropriate route was the special committee. And Your Lordship, there is, the first rule is the literal, of course, interpretation of this provision. It is clear that from the reading of that provision, there is nowhere in which the framers of the Constitution provided that a plenary session can be held to investigate into the conduct of the Deputy President. And in fact, Your Lordship, from Article 145, it is clear that the Constitution was very clear in terms of the impeachment of the President, because it does apply to the President, and of the Deputy President. It went further to actually provide what needs to happen. And it is a constitutional buffer that was put there to ensure that whoever is undergoing the process of impeachment will get the benefit of the law. And I will shortly be reading the provisions of Article 27 of the Constitution, where it actually provides for equal benefit of the law. And maybe I can just quickly, as I finalize, read section 27(1), which provides that every person is equal before the law and has the benefit and has the right to equal protection and equal benefit of the law. So, Your Lordship, under Article 27, there is a benefit that has been, under Article 145(3), there is a benefit that has been put there by the Constitution, and which the second Deputy President was entitled to benefit from this provision of the Constitution in terms of having a special committee to investigate into the allegations that were leveled against him. So, Your Lordship, and if we look at actually that provision again, if we were to take the position that actually a plenary is also a route that is provided here, it will actually amount to a discriminatory act in the following sense, my Lord and my Lady, that it means that the Senate will be deciding, there is no criteria as to when the special committee will be applied by the Senate and when a plenary will be applied by the Senate. And Your Lordship, what that means is that it will depend on whether the Senate actually, you are in good books either with the Senate or whoever who is in charge of those impeachment. Because there is no procedure that actually provides that under these circumstances, a special committee must be undertaken, and under these special circumstances, then the plenary can be undertaken. It is left to the Senate to determine at whichever time they are going to use whichever mode. And Your Lordship, that has been demonstrated even in the impeachment of governors, where you find that some governors are subjected to the plenary, others are subjected to the special committee, without any justification why this was used over that. And therefore, the purposive interpretation and holistic interpretation of this article will yield a conclusion that at all times when it comes to the impeachment of the President or the Deputy President, a special committee must be constituted by the Senate for purposes of hearing, investigating, first of all, whether the charges have been substantiated before a recommendation is made to the Senate. And finally, the other rule that I want to rely on is on the Latin maxim that expressio unis est exclusio alteras. So, Your Lordship, that provision basically means that what has been expressly provided under the Constitution, any other thing is excluded. Your Lordship, the framers of the Constitution, if they wanted to have both modes available, then, Your Lordship, there was nothing difficult in them saying that either they investigate by the committee or by plenary. They expressly excluded the provision of a plenary, because what the Constitution wanted is a process where the president or the deputy president is given an opportunity to, first of all, for the Senate to first of all investigate by the committee, and finally that the matter be deliberated in the Senate. So, Your Lordship, in light of those brief submissions, we do pray that this honorable court finds that the impeachment of the second deputy president was unconstitutional, invalid, and null and void. Those are my humble submissions.
Can you in just 1 second tell me the remedies we're seeking in this petition?
Yes, Your Lordship. In our petition, we have several prayers that we've sought, and the first prayer is a declaration that the appointment of Professor Kithure Kindiki as the Deputy President of the Republic of Kenya was invalid, null and void for the reasons that we've given in terms of there was no public participation. Your Lordship, another prayer that we did seek is a declaration that the National Assembly and the Senate were under an obligation to undertake separate public participation in respect to the impeachment of the second deputy president. Further, Your Lordship, another prayer that we sought for a declaration that the public participation that was conducted by the National Assembly on 4th October and 5th of October was not proper, effective, and meaningful within the provisions of Article 10 and 118 of the Constitution. And finally, that the impeachment process of the first interested party, being the second deputy president, was invalid, null and void. Those are the submissions. And Your Lordship, of course, cost of this petition.
Thank you very much.
And we do support the position that was taken by the first petitioner. Most obliged, my Lord.
Thank you. Mr. Umoke.
Your Lordship, I would like to present my petition on a fresh day. So I'll let Ms. She can go ahead.
Are you revising the directions which we made without application?
No, Your Lordship. I would like she's for the second petition. She can proceed.
So why do you want a fresh day?
No, I can still carry on today.
Yes, my name is Teresia Wanjiru Kimoto Makazi from Tess Kimoto and Company Advocates Kerugoya. I'm for the second petitioner. So my petition is the one dated Okay, thank you. It's the one dated 25th September 2024. And in that petition, we are seeking several orders. And in those orders that we are seeking, one, we are seeking that the then Honorable Rigathigachagua, there be a declaration that the constitutional rights of the applicant, who is the petitioner, provided for under Article 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. And that the first respondent, who by then was the current Deputy President, be ordered to issue an apology to the NIS members and staff due to the utterances and speech made on the 26th June 2024. Cost of the petition and any other relief the court may deem fit. Of course, we wish to say that our petition has not been opposed by anybody. No, let me finish. And we rely, of course, on the facts in support of the petition and our supporting affidavit as it is. We also wish to say that the reason why we had done an application to stop the impeachment proceedings is because
I don't like doing this. But clearly, Ms. Kimotho's petition is overtaken by events. The petition sought an apology by the second Deputy President to the NIS. That did not happen. The impeachment occurred. A vote was taken on that question, and it is the subject of the first petition argued by Senior Counsel Paul Mwite. So Ms. Kimotho should sit down. Thank you.
No. We are opposed to that because that's not true. The apology we were seeking is an apology from the Deputy President, whether he's sitting or not sitting. So we are very much in place. And again, we also wish as I proceed, before I was interrupted by my senior, I wish to say that we are also in support of, we are against the process of impeachment. And we are going to say why, if I'm allowed to say. The reason why we are in support of, why we are against, the impeachment process is that the grounds that we relied on in our petition are the same grounds that were being litigated by the Senate. The judge, when we went to, our petition was first, E013. When we went to the High Court at Kerugoya, we raised these issues. The Senate had not yet started the process, the impeachment process. And so we felt that if we were hard fast, then this whole issue would have taken a different turn. Because once a case is pending in court, once the issues that are being raised are the same issues being raised in the Senate, then we ought to have been hard fast. And that's what we have been raising from the application that we did, and even in this situation when we are arguing our petition. We again say that if you look at the entire process, any person who goes to court must be heard. That's an Article 50, fair hearing. Then if the same issues that are being raised here are raised there, then of course there's an issue. It shows the senator, because we served the Senate, and the Speaker clearly acknowledged that there's a petition going on in Kerugoya, but they ignored. This can only show their minds. They had made up their minds. And that's why now we are in support of the petitioners against the entire impeachment process. And this point is very, very important. Again, if you look at when we were consolidated, there came the issues again that are being raised here. Public participation, which on our part, we are supporting. We are saying the public participation that was not done well. His Excellency Rigathigachagua, His Excellency the President of Kenya, William Ruto, are people who were voted by Kenyans as a duo, not individually. So now when His Excellency, one duo, one person, one part of that duo is subjected to impeachment without the same process that was used to bring them to power, then that issue violates the Constitution. And why are we saying this? If you look at how they were elected, polling stations were everywhere. Each constituency, each polling stations in the wards, people were allowed to vote. So now when it comes to public participation, in where now we want to remove one duo, why are Kenyans not being told, come, let's get your views on the removal of one duo that we elected? How can we be told we don't have a right to be here right now? We do have a right, because if Kenyans did not participate equally as they did participate during the elections campaigns, then the process, any public participation that is said was done here was a sham. The second issue, why we are in support of these petitioners. Again, you can see how, and these are allegations that are in public domain. In fact, in our petition, we are accusing the Attorney General of these issues. Everybody kept on saying the MPs were given 500,000. The senators were given 1 million. These are allegations in the public domain. Can we say this process was fair when people out there are claiming there is bribery? We have seen several talk shows, people continuing saying these issues. So we are objecting to that process that was done. The other point that we wish to say is, okay, again, that was repeated, but I can emphasize, on the day of the Senate, we see the then Deputy President, Rigathi Gachagua, falling sick. We have served, there is our order, standing there, the Speaker of the Senate acknowledging that yes, we've been served with an order. Then suddenly the Deputy President becomes sick. And then what happens? The Senate does not care. They give a few hours, a few days, and then say, we will proceed, whether he appears before us or not. We go back to Article 50, fair hearing. Fair hearing means, however that person is, he must be allowed to give us his side of story. Kenyans were waiting. Kenyans were watching the TV. They wanted to hear His Excellency Rigathi Gachagua tell us, we voted for him. We want to know what happened. What happened, yet we voted a duo. So this chance we were not given. What we saw was in Senate, people come in and the lawyers speak and other allegations, paperwork. So Kenyans would have expected to hear his side of story. So in that, we say he was not given a fair hearing, and therefore that impeachment process was not conducted the correct way. Yes, I think my points, those are my few points. They are very fiery, so I don't want to keep...
Of course they are.
Yeah, I don't want to spoil anything. That's all for me.
Thank you. They are fiery. Thank you very much.
Okay.
Yes, thank you.
My Lord, Tess forgot to say that Kerogoya is in Kirinyaga.
Oh, yes.
Correct.
Can we see how many people are yet to submit? How many?
My Lord, there's the third petitioner.
Mr. Kibe. Where is Mr. Kibe? Can I see how many are yet to submit? So we'll proceed until 6.
Did your lordship give an indication of up to what time we will be sitting?
6. 6.
Today?
Yes. You want us to amend it?
No, I was just asking for clarity on up to what time today we will be sitting.
You know, these people, I don't know where the councils have arrived from, because when we were taking quorum, they were not this large. Some people have just appeared. Some of the councils have just appeared now, because you spoke about 8 people. 8 councils, yes. And then after that, we have had now, I see quite a number of councils are here. I don't know, maybe.
Probably a misunderstanding. The 8 council I stated are the 8 council appearing for the first petition. There are many other petitioners, and these council are for those other petitioners.
Yes.
But looking at the number, it's a matter entirely in your lordship's
so we can do up to 6. Then after that, we can make further directions.
Okay.
Yes.
Thank you, my lord.
My Lord,
My Lord, just so that I may get some clarity, the two of us going, 6 o'clock, that's in 30 minutes. It would be better if we took a proposal to get directions from the court, because I would definitely need more time. Unless maybe I might be lucky that there's one of us who can do it in 30 minutes to make 6. Okay, he's willing to do 30 minutes.
Okay.
Yeah.
Your Lordship, once again, my name is Morara Moke. I am the 43rd petitioner. I filed a petition on my own behalf, and I was deeply offended by the manner in which the impeachment process was being conducted. And therefore, in compliance with the Constitution, I came before this court to defend it. It was not about my political alignment at the time, but about the Constitution, and that's why I'm here today. My petition is E027 of 2024. I have a supporting affidavit sworn on 9th of October 2024.
E0?
Sorry?
E047?
E027 of 2024. The same date. On the same date I saw the affidavit, 7th of October 2024. I filed very brief submissions dated 1st of April 2026, in which I sought to address 2 issues, as I do not wish to repeat what the first petition has already submitted on, but I fully support the submissions presented by the councils for the first petitioner. And I will proceed to make a few additions. On the issue of public participation, I personally attended the public participation exercise at Kiambu Social Hall. I'm a resident of Kiambu County, although I'm born in Kisii. I attended, and I can confirm that the form that was provided to the participants only summarized the allegations against His Excellency Rigathigachagua without provision of any particulars or any evidence in support. So I can confirm as a participant, and there is no response in opposition to my petition to challenge that position. There was no evidence in support of the various grounds of impeachment as presented to the public. Secondly, there were no attachments of His Excellency Rigathigachagwa's response, which at the time had already been filed before the National Assembly. It was never provided to the participants. And as Aleron stated, the public was only being asked to give an opinion of yes or no, and only a very small provision at the bottom of the form to say any other thing. I also would like to indicate that the manner in which, rather the form, the language was only in English. And as you know, in this country, we have two official languages, English and Kiswahili. Earlier on in Swanya's submissions, he did talk about the BBI case. Actually, in that case, I prosecuted that point on providing different languages when it comes to public participation, especially on an issue that is so important as this impeachment. It was only done in English. There's no explanation why it was not done. They could have taken time, but because there was the hastiness with which this process was being carried out, of course, there was no attempt to provide for any other language. In my petition, I gave a background to the impeachment process, and I did find fault with the lack of partiality on the part of the Speaker of the National Assembly and the Deputy, and the remarks they made prior to the impeachment process. Starting with the Deputy Speaker, she did say, mimi mwenyewe nitampeleka nyumbani, in a public rally. Around the same time, the Speaker for the National Assembly even quoted a verse from the Bible about getting rid of something that is considered to be inappropriate in reference to the Deputy President, even before the impeachment motion was presented before the National Assembly. And this, as we said, while they do not vote in an impeachment process, they preside. So it is extremely important that the two individuals who have the mandate of presiding over the impeachment process ought to act with impartiality, and they have to have no bias. And I would have to say that the two of them totally failed, and that vitiates, in my opinion, in my own submission, that vitiates the entire process. They should have refrained. They could have been more restrained in their remarks, even if they that's what they believed. But they totally rendered the process unacceptable. I'll come to another issue. In the manner in which the grounds of impeachment were debated, and you look at the Hansard for the National Assembly, I'll make reference. I've seen multiple copies, but there's a copy before the court, I believe. I would ask you to look at page 18.
Which dated?
The Hansard is in reference to the impeachment proceedings. I believe it should be before. Without it before this court would mean that I'm not able to point out the specific date, but it should be before the court.
We had two.
The one for the National Assembly. I'm making reference to the one in the National Assembly. It's 5th of October, 2024. Sorry, Your Lordship, 8th of October, 2024. In that particular Hansard, at page 18, I picked the remarks that were made by the Member of Parliament for Suba South, Karoli Omondi. At page 24, I picked remarks that were made I believe those were made by Honorable Catherine Omanyo. And also, I'll take the two of them. So they went ahead and introduced other issues. Also, I forgot to mention the Member of Parliament for Mavoko, Patrick Macau. Actually, that is at page 24. Then at page 42 and 43, you will find those of Catherine Omanyo. I will not go into what they said, but I would ask the court to look at some of the issues they said, which to me were personal issues they had with the Deputy President, or some long-held grudges, which they used as their reasons for endorsing the advancement of the impeachment to the Senate. This being an impeachment trial, which, as we said, in the standard set in the Wambora case, which requires a very high standard, and the Constitution, which also talks about grossness and seriousness of the misconduct and the violation. You cannot introduce any other ground, even if that's what is your reason. You have to debate, you have to vote on the impeachment on the basis of the grounds that have been stated in the motion. So that is another failure, which on that basis I would ask the court to find that the impeachment failed to meet the standard, the constitutional standard. It has to be the constitutional standard and threshold, and therefore it ought to be declared null and void. Your Lordship, I would now move to present on the issue of lack of legal mechanisms, or rather legislation, to operationalize Article 150, in this case, of course, which incorporates the other articles on impeachment. Again, on this issue, I did make a presentation in the BBI case on the lack of legislation. In that particular case, the issue was lack of legislation for collection of signatures. And that was an important issue in the BBI case. And the court agreed, and I would ask this court to make that finding, which is extremely important, that this kind of a process, being so important, must have legislation. And I would like to state why it is important. For instance, when you look at the provisions touching on the election of a president and a deputy president, it's very clearly provided on the judicial review available to any party who is dissatisfied with the process. It's elaborate. It has to be that you come before the court, you raise your issues, the court makes a decision. Thereafter, then whoever is elected is sworn into office. So the Constitution, in a way, has actually enforced some conservative relief. However, that is not provided on the issue of impeachment, and therefore, just as important as the process of occupation of that office, so should be the process of exiting that office. And that, therefore, would require legislation to address that issue. We were, before this court, we argued on the issue of conservatory orders. Your Lordship, it leaves us in a difficult position if this court was to find that this impeachment process was unconstitutional. How do we cure the fact that His Excellency Rigathigachagua was hounded out of office, replaced, and now he's left without a solution? Because if we say, for instance, that if we were to order him back to the office, the kind of situation we face is difficult. And that is why it's important to have legislation to provide for room for judicial intervention before the swearing in of the new occupant of an office, if the court was to ever confirm the impeachment process. It also would also aid the person, the incoming, not to come in under the cloud of illegitimacy. Because as we are here today, issues have been raised by my colleagues about the fact that the replacement came into office hurriedly without any safeguards. There was no vetting. Because being an appointee, then it reduced him to that level of requiring vetting. While for an elected deputy president, the vetting is with the people. They vet and they vote. So I would say that this is an issue that leaves us in which actually paints a cloud of doubt on the efficacy of fair hearing in the Constitution. And my hope is that the judiciary would acknowledge that the fact that we did not have conservatory orders in place was a problem. And I would explain why. In the Constitution, there is a line of succession provided that if the president is not there, the deputy president will come into office, would act in that period of vacancy. If the two of them are absent, there is a Speaker of the National Assembly. And the fact that in the ruling on conservatory orders, we did recognize the significance of this office. Therefore, it will become so important if we had legislation to even provide for such situations. What should happen? In my petition, I have only asked for 2 reliefs: a finding on the unconstitutionality of the process, and on the issue and the question of a lack of legislation, which as I submit before this court and ask this court to align with your colleagues in the BBI judgment, that lack can render this kind of a process flawed. I so submit to your lordships and my lady.
Thank you.
My lords and my ladies, I see it is around 5:50. I'd requested court for 20 minutes, but based on what has been submitted, I'll only take 10 minutes because I wish not to repeat and regurgitate what my seniors and the petitioners who have come before me have already told this court. Your Honor,
I don't think we'll be able to hear you now because there's another petition we are mentioning and time is well spent. Just give us a few minutes, we'll give you directions.
Much obliged to you.
So I think our time is well spent. We have to adjourn to the next hearing date, which is 7th of May. We'll proceed with the petitioners' counsel who have not submitted, and thereafter we will proceed with the respondents on 7th of May. Should I suggest that we start at 9? Yes, 7th of May at 9. So with that, I think, yes?
No, I was waiting for my lord to finish giving the directions.
Yes. Yes, I've finished. We'll adjourn until 7th of May at 9. By that time, I think we'll have the services of the ceremonial hall. So we'll be in the ceremonial hall.
My lords, on behalf of the entire bar, I wish to thank the court for the patience with which the court has listened to those who were able to address the court today. Secondly, I forgot to point out that the petitioner, His Excellency Rigathigachagua, has been present in court, as is entitled to, together with his friend, my colleague, Honorable Eugene. I thank the
Thank you. Thank you very much.
My lord, I know that I should not go after my pupil master, Mwita Senior. But my lord, just for the record, when Macharia submitted, he referred to senators as goons. And I hope that must be struck out of the record.
I think my colleague Tom Macharia. My Lord, through the court.
Excuse me.
Tom Macharia was talking about what you might have organized in Kisumu.
Excuse me, please. We want to confirm whether we had that.
Yes, my lord. He said
it does not appear in my record.
Yes, he said that democracy, that parliament, that the vote that is tantamount to goonship in the legislative process. He did. And the senator for Kiambu is here. He's not a goon.
This is how they impeach the deputy president on their own record. Imaginary record.
Thank you.
My lord, with your kind permission.
Yes.
My matter still is yet to be mentioned.
Yes.
E586. And my lord, I would have been much more happier now that my lord friends are here. In fact, I would have submitted, and how beautiful it would have been, because the memory of it would just have lingered. So that, my lord, but the petition got separated. It's now floating out there.
You separated yourself.
My goodness. My lord, I do appear for the petitioner.
Where is the file?
Yes, my lord, Harrison Kinanjui. I appear for the petitioner.
Yes.
I believe there are some of my learned friends here appearing for the respondents.
This is petition
E568
of 2024. Joseph Enoch Aura versus the National Assembly.
I don't know why Mr. Gumbo now is escaping from. I was leaving the floor to him.
Thank you very much, Harrison. I was waiting, my lord, for the matter to be mentioned. I appear in that matter. My name is Gumbo Eric. I do appear with my learned friend, Mr. Paul Nyamodi, for the first and the third respondents.
For the record, my lords, I appear for the fourth, fifth, and sixth respondents, together with my learned friend, Mr. Mukele and Ms. Thanji from Senate.
My lord, my name is Mudhomidhin Kolu. I appear for the 10th respondent, together with Messrs. Moses Kipkogei, Kennedy Mele, Boniface Mawera, and Kenson Mutethia.
Good evening, my lords, my lady. In the matter, my name is Dennis Nkarechia. I'll be requested to hold brief for Ms. Joy Anami, Mr. Mahat Somen, and Mr. Nura Hassan, who are on record for the 9th respondent, the IEBC.
Yes.
My lord, we do have the interested parties, but the interested parties did not take, should I say, interest in the petition. So I think it can just be marked as absent. My lord, we were supposed to appear before you on Friday last week. However, for reasons explained to us, it was not possible, by reason of which the petition then was deferred to today. My lord, you advised that I come at 10, and I have been just lingering here. I'm probably one of those advocates that you said you haven't seen, but we were outside there, and we seem to have flooded your courtroom all of a sudden. I don't wish to take too much of your time. You've spent the whole day here, Your Lordship, my lady. And therefore, I would beg that you give us directions on the way forward. Although, I should add, we have sought the intervention of the Court of Appeal, excuse me, and was a bit